Under Jason Autry's theory, the body is still in the white truck, right?
The last Jason sees of it.
Then, does it make sense then, at that point, after calling Autry in to come help him dispose of the body, they then just go to Parsons to lollygag?
I don't know. I mean, it may make sense. You may want to be seen out in public and away from wherever you put this body.
And leave the body at Shane Austin's house knowing the cable installer is coming that afternoon? Have you reconciled the time of how they can get all this and back to the ATM at 11:12?
Okay,
you haven't, had you?
No.
Because you didn't know that, but you knew they were in Parsons.
Okay, let me answer. I haven't right now.
Fair.
Okay? Did we reconcile that time at the time of the trial? I do not remember.
The proffer session, you said Mr. Scholl had the upper hand. Would you go so far as to say you knew you were not going to win a case if you just tried Jason Autry?
We didn't want to have that trial. I'll say that. Like, what I would say, I knew I wasn't going to win because we could get to a jury with Dylan Adams' testimony and with the fact he lied about his whereabouts and things like that. But it was not a strong case at all.
But you come to the conclusion Dylan Adams' statement wasn't true.
That he was holding a lot back.
And then when you saw the cell records, you realized it wasn't true.
So the cell records don't become particularly important until after we hear Jason's account. So it's a timing sort of thing.
But you had them.
Yeah, we had the records, yeah.
So you don't verify Dylan's lying to you until Jason Autry's prepared to testify?
No, we don't know the significance. So, we don't know that Holly travels to the river and back. We don't know what Jason and the significance of Jason and Zach traveling to the river and back that morning is. Nobody's pieced that together at all.
All right.
Hey guys, I think we are in for a great time. We get to watch a prosecutor on the stand in full. We watched, I think, maybe like a 25-minute-ish clip from Law and Crime, but Trial and Error Podcast has the full testimony of State Prosecutor Paul Hagerman. If you're new to the Zachary Adams case, this is all post-conviction stuff that we're going to be watching in this stream. So he's fighting for a new trial. We have a prosecutor on the stand as a witness, which is always a messy time. And those are just some clips I pulled from the very end of the segment. I didn't watch the whole thing. So just on that little bit from the end of this testimony, I think we're going to hear some crazy things from a prosecutor describing how they proceeded with bringing these charges and deciding how they would be able to put on a trial that would get a jury to come back with a conviction. We are also in the middle of rewatching the actual trial from 2017. So after we get done with this is going to be 2 hours and 37 minutes. We're going to redirect to another trial watch stream and continue with day 7 of the rewatch of Tennessee vs. Zachary Adams. So I'm excited because those clips from the end were already a hot mess. We have a prosecutor who's like, well, we didn't really know how we were going to make our case stick, what proof we were going to show. We tried Dylan Adams first. And we just went with Dylan Adams until it was so bad we realized there's no way we can call Dylan Adams to the stand at a trial. And who cares if his story isn't making sense? We just think he'd be a bad witness. So let's go to Jason Autry, who becomes a star witness at the 2017 trial. We've done some deep dives on the issues with Jason Autry. If you want to go check those out, they're linked in the description. Oh, it's going to be a time. It's going to be a time. And then last night, we watched in our Discord, we watched Thin Blue Line, another story of a wrongful conviction, although, it's cinematic, it's theatric. So there's different flair as we were watching the Thin Blue Line. That was recommended by a chat member, James Phipps, so thank you. Great recommendation. And in that, I totally recommend it if you haven't seen it. It's on YouTube's Movies and TV channel for free. They have interviews, like present day when it was made, interviews with prosecutors from that trial that seem like even though they know now that it was a wrongful conviction, in their interviews they still stick to their guns. They are still assured that they had the right guy, even though the conviction is now overturned. So we're going to see that happening in real time, at least being argued by Zachary Adams. And you don't often get to peek behind the blinders like this with the full hearings. So really, really excited, you guys. Strap in. Hey to everybody tuning in this morning or afternoon or evening, depending on where you are. Hey to Keith over in Chicago. Geez, Louise is getting some coffee. Let's get into it, you guys. Do a volume check. Let me know if it needs to go up or down.
Mr. Bates?
General Paul Hagerman. General Paul Hagerman.
Paul Hagerman, please. Hello, sir. You'll stand there and be sworn. Mr. Clerk.
Do you swear or affirm the testimony you give to be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Please have a seat.
State your name, sir, and spell your last.
My name is Paul Hagerman, Hagerman.
And what do you do for a living, sir?
I'm the Assistant District Attorney
What district?
in the 30th Judicial District at Memphis.
And how long have you held that post?
24 years.
You were a prosecutor in the prosecution of Zach Adams, Dylan Adams, and Jason Autry.
Yes, sir.
And when did you come on the case?
Not sure about dates. The case had been going on for a little bit. Jennifer Nichols and Ray Lapone were on the case, and Ray had recently taken another job and gotten off the case. Miss Nichols got Mr. Ragland, Mr. Christensen, and then me to help her on the case after that.
Did y'all have a specific assignments?
No. Miss Nichols and myself we were the primary attorneys that worked on it the most.
Okay. Was the case a death penalty case when you came on?
Yes.
And when you came on, had you reviewed the 2014 recorded statement of Dylan Adams?
After I came on, I reviewed it. Yes.
Okay. And at some point, you received cell phone records of the defendants in this case.
TBI or the other investigative agencies had gotten cell phone records for the defendants. That was part of the file.
Okay. When did you realize Dylan's statement was impossible with the cell records?
So when I first got on the case, of course Dylan's statement already existed. You know, it was recorded. It wasn't until Mr. Autry gave his proffer that we realized the significance of a lot of the cell phone proof. So maybe, I guess that's my answer to that, unless there's a more particular question
Okay.
about what you mean.
You realized Dylan's statement could not be true.
Based on the cell phone proof?
Yes, sir.
Just say it.
I wouldn't say that. I wouldn't say I realized that.
Well, how do you reconcile them?
Well, I don't know that they can be reconciled.
What do you mean by that?
Okay. I mean, Dylan's statement was, I want to say, is limited because it does go on for a decent amount of time, but it doesn't provide details as to exactly, when and where and every party's movement, during the incident, or after the abduction and pre-abduction, and then during.
Do you remember reviewing Dennis Benjamin's statement that Dylan gave to him that became the precursor to the recorded interview?
Yes.
The witness can be passed Exhibit 104,
It's the last exhibit.
next to last.
Next to last exhibit, sorry.
Do you have it in front of you?
I do.
And can you go to page 3.
Remember, we kept the IR on the front, so is it page 3 of the handwritten portion?
No, sir, of the typed.
Okay.
I've got 1, the back is 2.
And then 3.
And then 3.
Yes, and
Gotcha.
you see Dylan's timeline. John Adams' timeline.
Okay.
Do you remember looking at this?
Yeah, this is one of almost thousands of IRs that I would have reviewed. Absolutely.
Do you remember reviewing this?
I absolutely would have reviewed this.
Okay. And you see a timeline of arrival 9:30 to 10 a.m.
I see that on this IR, yes.
10:05 to 10:50, Autry raping Bobo.
Okay.
Do you remember the evidence y'all?
What was the time frame? So 45 minutes
Okay.
with Autry.
Do you remember the evidence y'all submitted to the jury about where Mr. Autry was during that time frame?
Yes.
Where was he?
I remember Mr. Autry's testimony from the trial, and then I remember cell phone records with regard to Mr. Zach Adams and Mr. Autry's whereabouts during this time frame.
And where were they?
Which time are you asking about?
Between 10:05 and 10:50 a.m.
You know, I can't say now, years later, exactly, but I would think that would be about the time that they would be getting back from the river or in their travels.
Okay. These are two totally inconsistent realities.
You asking, I think this is a summary of what Dylan Adams would have said in his statement.
Right.
Yeah, and if he got things wrong, then absolutely he got things wrong. But Mr. Dylan's Adams statement does not match Mr. Autry's statement, if that's the question.
Then from 10:50 to 11:10, John Adams raping Bobo. 11:10 to 11:55, Zach Adams raping Bobo. Are you aware where the cell phone records put these defendants during that time frame?
Again, we're talking years later here, and so from my memory, the abduction is around 8 in the morning. Rape, travel to the river, come back. And from my memory, comeback time would probably be around 10:50 or something. I don't know if in particular.
Well, let me ask you this. Do you remember a moment when you realized this Dylan Adams story doesn't make sense?
I remember watching Dylan's statement on the video recording. I remember speaking to Mr. Dylan Adams, and I remember thinking that he is not telling the truth about what happened, and his details with regard to what happened, are insufficient, incomplete, held back, that his statement was incomplete, if that's what you mean.
When you say insufficient, do you mean insufficient to get a conviction?
Against whom?
Zach Adams, Jason Autry.
You wouldn't
You
want
charged all of
Dylan's
them.
statement to be the only piece of evidence in front of the jury. You would need, at that time too, corroboration under the law. And so if you're actually asking about Mr. Adams and Dylan's statement, you could build a case against Mr. Adams, which you could win with Dylan's statement being part of it, because there was other proof against Mr. Adams.
But if he said a series of events that were impossible to be true, that's concerning to you, isn't it?
Absolutely. That's why I said when I watched the statement and talked to him, I thought there were details that were wrong. I think he was holding a lot back and not telling.
And
And again, I highly recommend watching this if you haven't seen it. We've talked about it. We've done some playthroughs over here, but the easiest way to go look at it would be the Trial and Error podcast. So there are links in the description. But this statement with Dylan Adams is the statement that we've heard several times in these post-conviction hearings, concerns that it was Brent Booth and Jackson doing the interrogation. And Jackson is rattling off question after question with each of the details. And you found the pink panties, right? And there was a green couch, right? And Dylan Adams, who has cognitive disabilities, is just sitting there like, barely audible responses. And the details are not coming from Dylan Adams. And this interrogation takes place 5 weeks after Dylan Adams is released on probation after picking up a federal gun charge. And one of his probation conditions is to go live with, every time I rattle off the details of this case, it seems like I'm making it up, but it's true. His probation condition is to go live with a retired Memphis police officer, Dennis Benjamin, who is also working in capacity as a private investigator for Karen Bobo, the victim's mother. And this is what Douglas Bates, the attorney for Zachary Adams, is trying to ask this state prosecutor about. Like, do you think this is kosher? And he's like, well, like, this is the beauty, in a sad way, a bittersweet way, of having a prosecutor on the witness stand. Can't make it up.
at the time Dylan gave his statement, he did not have the cell phone records.
Yeah, I assume he did not.
When Jason Autry did in early 2017, he had the cell phone records. Correct?
I was told that Jason Autry himself did not have the cell phone records.
Who told you that?
Mr. Scholl.
Okay. We'll come back to Mr. Scholl. Do you remember an extra copy of the cell phone records going to Mr. Scholl in November of 2016?
I wouldn't have remembered it, but when I was looking over stuff to prepare, I saw that.
Okay.
Or I was told about that.
That's out of the ordinary.
No, it's not.
It's not. Why is it not?
Well, with cell phone records, it's quite often the case that the original form in which we would provide them is not what the defense's expert wants. So providing the cell phone records in a different form later on happens all the time in cases like this.
So when did Mr. Scholl tell you Jason doesn't have his cell phone records?
As when we first approached that defense team about the possibility of Mr. Autry cooperating or testifying, some time passed between then and when he actually came in and gave the proffer. Mr. Scholl told me during that time period that Jason had told him the whole story, had given the whole account, but that Mr. Scholl and his investigator wanted to check things out. They wanted to see it conformed with reality. And one of their big truth tests of Mr. Autry was the fact that he did not have the cell phone records, and they looked at his story, compared them to cell phone records, and that added some credibility to Mr. Autry with regard to Mr. Scholl.
At this time, Mr. Scholl had made public comments that Mr. Autry had nothing to do with the rape, kidnapping, and murder of Holly Bobo, correct?
Do not know.
You remember him on the news saying that on the lawn at Decatur County Courthouse?
I did not watch the news.
Do you remember his motion to continue in August of 2016 saying, I try to go and take my discovery to my client. The jail confiscates what I bring to him. I don't have a place to set up my laptop. There's voluminous terabytes of discovery to go over. And I'm not prepared to try this case in whenever the trial is set.
I don't know if I was on the case yet, but that sounds familiar.
You were on the case in August of 2016, correct?
Yes.
And so when did the conversation where Mr. Scholl now has been able to go through all this discovery, he said he hadn't gone through in August of 2016. When did he tell you?
So if you go, I do not know a date for you, but if you go to Mr. Autry's proffer agreement, it would be some time period within a month or two before that.
Okay.
Mr. Banks, just to clarify, Mr. Scholl is Mr. Autry's attorney?
Yes, sir.
Okay.
Did you ever see the video from the ATM machine before the trial?
Watched an enormous amount of videos. Because the first time we talked, or the first time we met, you mentioned this video. And so I've seen it since then.
Okay.
I probably saw it back then. I can't tell you one way or the other.
You have no independent memory of saying, wait a minute, the same Chevy that's been impounded appears to be on the ATM machine.
No, I have no independent memory of that.
You have independent memory of Joe William Walker issuing a subpoena to Shane Austin's bank records,
No independent knowledge of that.
of stating there's an ATM transaction along with a Sonic and other places. Do you have any independent memory of that?
I do remember trying to track the whereabouts of the defendants, before and after the homicide. The Sonic transaction is familiar to me. I think I remember an ATM transaction, but not 1,000%
How do you not know
certain.
this? This is a death penalty case. This is a death penalty case. And look how dumbfounded we are when it comes to a lead prosecutor, one of the leads. He was a trial prosecutor. The decision for trial strategy was largely in his hands. What evidence we're going to look at and what evidence we're going to conveniently ignore. Decisions in his hands. I think I remember something about that ATM and the truck video and all these things that independently, let alone as a whole, help provide an alibi for the guy we want to take to a trial. Like, what are we doing?
Do you remember Mr. Agent Walker saying these transactions were not covered by our videos?
I don't remember that.
Do you remember ever saying what was from the ATM machine was labeled BP in discovery?
Do I remember there being a BP video?
Do you remember what was from the ATM machine being labeled BP?
I can't say that. I I remember that.
You remembered Miss Thompson requested multiple discovery supplements from
Oh,
you.
for sure. It was ongoing, for sure.
And did she tell you there were things she couldn't open from you?
Absolutely.
What was your response?
Well, discovery was a huge deal in this case because, as you mentioned, there was so much material. There was a hard drive that was over 4 terabytes with actually over 4 terabytes on it. When I first got on the case, there had been some ongoing discovery issues. And so that's how I jumped into this thing. My first court date, I met with Ms. Thompson and the attorneys, and we decided it would be a very good idea to get together and do a discovery conference where we could all sit at the table with TBI, go through everything, and make sure that they had everything, that we'd given them everything, and there wasn't stuff.
All right, this isn't answering the question of, did attorney Jennifer Thompson, trial counsel for Zachary Adams, ask you for help being able to open and access this BP file?
Like you said, that they couldn't open or at least establish lines of communication there. And so we went to Nashville at the TBI office and we did that discovery conference. After that, all the attorneys, especially Ms. Thompson, would make specific discovery requests to me, and we would, do what we could to get that to them.
Y'all's response at times where you've got the format we've got?
So when we had that discovery conference, we discovered some things, that a large number of the attachments to the various IRs, like you gave me, were unable to be accessed or were not there. And so we got with TBI and we were able to hand over all these attachments that she had been, obviously very interested in. During the conference, really quickly into it, when she confirmed with TBI that what they had was exactly what we had. So that
What's the problem with this? What Doug's line of questioning is great. He first lays out, you ignored this alibi evidence. You didn't think it was worthwhile to go and check out ATM transactions, possible video surveillance footage, not just from the ATM, but also the stores nearby, like the Sonic and inside the gas station. All of these things that the defense now knows that there's pieces to put together for a comprehensive alibi, not just for Zachary Adams, but also for Dylan and Shane. Now, your excuse is, well, what was the quote? He said, you've got the format we've got, which means you didn't try to open it. You didn't try to look at it. So when we hear all of these other conversations, all this other testimony from Jennifer Nichols and elsewhere, well, the alibis, we heard they had alibis from Terry Dykes, but we found out they weren't really checked out. It was you that didn't go check them out, and it was you that by not checking them out were able to ignore that the alibis pan out. The alibis have weight there behind them. All of this wordplay in this post-conviction hearing is them trying to defend their conviction and make excuses and hedge around the fact that they're the ones that did not go and do the work, do the due diligence to check out this alibi work. And yet they're going to flip that on Terry Dykes. But that's really what he's saying right now. We couldn't access the files either, which means you didn't access the files. You didn't do your job before trying to prosecute somebody with the death penalty hanging over them.
I want to say appeased because she kept on working and everything, but that quieted a big concern. And then when anything particular she couldn't access, like you said, we'd get with TBI and provide it to her in a different format if we could.
But you didn't do it for this.
There were still things she complained about in her last request for a continuance.
I don't remember.
Okay. Do you remember Judge McGinley asking Ms. Thompson, when do you want to try this case? And she said 1 year from Mr. Autry's proffer. Do you remember that?
I do remember that she made continuance requests on the eve of trial or maybe even on trial day.
Do you remember Judge McGinley saying, I think you want to try this case when pigs fly?
I don't remember that.
Okay. I'm just going to ask you a question. Do you know the circumference of a .380 auto round?
No.
Do you know one was found by the remains?
I think I do remember that, yes.
Did you at any, well, let me ask this, I've never prosecuted. Do y'all do an independent investigation of what TBI provides you, or do you trust what TBI provides you?
You mean as a prosecutor?
Yes, sir.
I don't know if you ever trust anything. I mean, you try to look behind stuff. You don't do an independent investigation. I mean, we were given everything that TBI did, everything they collected from the FBI, all the various law enforcement agencies, and you read it and you process it and you ask whether or not it lines up with other stuff you see in the case.
Was there one agent you worked with more than others?
On this case?
Yes, sir.
No, it was all three. It'd be Brent Booth, Joe Walker, and Kathy.
And Ms. Ferguson's an honest person to you?
I believe so.
I believe so. It's
Do
crazy.
you remember when you put the cell records to where the defendants were on April 13, 2011? Did you ever map it out yourself?
No, I'm not capable of doing that.
In terms of what Agent Frizzell gave you, did you figure all this out?
I mean, do I put the
Yeah,
cell phone coordinates in the
No.
software?
To familiarize yourself where they are.
Yes.
You're in
I
various-
studied the cell phone stuff. I had a couple meetings with Agent Frizzell, and I studied the cell phone stuff.
And do you remember reading John Walker, the U.S. Marshal, whose work early on the case?
Yes.
Do you remember seeing a map of his work?
Yes, I do.
And if the witness can be passed Exhibit 5, please.
Guys, we watched Kathy Ferguson's testimony in part 6 of the deep dive. It's linked in the description. It was 4 hours of testimony, and it might get your blood pressure up. So if you missed that and are wondering who Kathy Ferguson is, check that one out.
Do you remember seeing this document?
I do believe, yeah, if this is Mr. Walker's, map that he did of the cell phone stuff, then yes.
And you remember Holly's cell phone staying on cell tower 1096 from 8:26 a.m. until 8:56 a.m.
What are you asking me? Does this
Yeah,
document reflect that?
Do you remember looking at this and seeing that?
I remember that looking at Mr. Walker's cell phone stuff, looking at Mr. Frizzell's cell phone stuff, and looking at the defense expert. I don't remember his name.
Mr. Reeves.
Mr. Reeves. Mr. Reeves' cell phone stuff.
Do you remember Mr. Walker, his opinion was the remains are going to be where her cell phone stayed inactive for 30 minutes?
I don't remember that.
Okay. Do you remember the effort to discredit Marshal Walker?
When discredit, do you mean cross-examine or question his qualifications?
Before trial and during trial?
About to cook.
I remember a vigorous cross-examination of Mr. Walker. I remember Mr. Walker, I can't remember the ultimate resolution of it, but either attempting to testify as a cell phone expert or ultimately being allowed to, but questions with regard to his qualifications and things being rather vigorous too. And then I was aware, because I believe this would have been before I got on the case, that other people in law enforcement were very skeptical of some of Mr. Walker's analysis and conclusions and things on the case.
Do you remember his conclusions being validated by the discovery of the remains where the cell
There you
phone
go.
in the same tower, the cell phone was inactive for 30 minutes?
I don't know that validates his various opinions and conclusions.
Hello? Hello? You have Marshal John Walker. There's 2 Walkers. So Joe Walker is a prosecutor. John Walker, U.S. Marshal John Walker, was working with Terry Dykes and trying to help figure out what's going on with this case. And he took the 2G data, got the same makes and models of the devices that were used in this case, and replicated the routes just to get better accuracy. And his report, his findings were, hey, the last place that we see Holly Bobo's phone ping, we're predicting that that's where you'll find her remains, that that's going to be the site of death. And that pans out. And now when this prosecutor's being checked about it, we're back to like squinting potato head again.
Remember there being no physical evidence from Swan Johnson Road up to where the remains were found. From Swan Johnson Road to the left, southwest Decatur County, up to the remains, there were no physical evidence left.
north of,
Yes, sir.
where is Mr. Austin's house? Is that,
If you're, I'll remove, it's very technical, General Hagerman.
I'm sorry.
While you're doing that, we mark this as an exhibit at some stage. What exhibit is this we're going to refer to?
15. If you have 15, could the witness be handed the,
Oh, is that the exhibit?
It's the visual aid is the actual
Okay.
exhibit, so, or photograph of it.
if the witness could be handed the exhibit binder so he can flip to it, Madam Court Reporter? Yeah, just give him the whole binder. Just to orient you, General Hagerman, the Bobo residence here in the bottom
Okay.
brown. The remains found up here,
By the cell tower?
correct? Tower 10961. There's no movement from 826 to 856 on Holly's phone. Shane house here on sector 31523. Zach's home on 31522.
Okay, so to answer your question, I think that there was evidence, there were various items that had been discarded, note cards and things north of Swan Johnson, because it was in proximity to Shane's house.
And if the travel was clockwise from the Bobo residence to where the remains were down to the last cell phone ping on Gooch Creek at 9:25 on tower 12573. That direction of travel, there was no evidence before the remains and physical evidence thrown out after. Right?
I don't understand, I'm sorry.
All right.
So the incident occurs on Swan Johnson,
Correct.
okay, and there is evidence north of Swan
And you
Johnson.
just look on Exhibit 5 to show the various pings on the cell phone route. 811, 816, then 826 to 856. Follow me?
Okay, so the
No.
purple note cards
Correct.
are going to be some type of cell phone location that's not a GPS ping, but is some sort of middle of a circle, I assume, having to do with approximate location?
Correct.
Okay.
And you understand that's what Marshall Walker, what he found in his work.
Which is what?
These pings along this route of Miss Bobo that morning up to this location where her remains were found.
I understand that he made this map, and I understand that the purple things on this exhibit have to do with cell phone location. It's not a GPS ping, so we're not talking about a coordinate. These notes should actually be large circles that cover a certain
Right.
circle. I have no idea how big the circles are.
You would agree then it's consistent with his work y'all called speculation that her remains were found where he said the remains were going to be found.
Yeah, I don't remember the part about,
And a bullet round, a spent casing was found right next to Miss Bobo's remains and personal effects.
I remember there being a casing that was found in proximity, yes.
And it's a .38, a 38 auto round.
That
Correct.
sounds familiar.
At any time, did you Google what the actual size of a .380 pistol round is?
We had conversations with people that
we?
did ballistics,
Who is we?
the prosecutors,
Okay.
and then ultimately we had a meeting with Dr. Ross, medical examiner, who opined about, the size of the wound and what type of caliber could make that.
And he says it was anything no bigger in size than .36, right?
I don't remember.
Are you aware that a 380 is not .38 in size?
I do not know. I mean,
At any time did you say, Dr. Ross, thank you for your service to the state. Can you tell us, is the round next to the remains that verifies possibly now Marshall Walker was correct and the direction of travel was clockwise, is that round larger in reality than .36?
I don't remember asking him that. He was Mr. Christensen's witness, but obviously I would have been familiar with the entire case.
Are
We
you sure?
definitely talked with Dr.
Is that obvious? Did he say obviously? I'm not so sure about that, buddy.
He was Mr. Christensen's witness, but obviously I would have been familiar with the entire case. We definitely talked with Dr. Ross about what caliber would be consistent with the wound, that he found.
Okay.
And then he offered his sort of expert opinion with regard to that.
Where in your professional opinion was the body and Miss Holly's body and her cell phone separated?
I don't have a professional opinion about that, but you've heard or you've read or seen Mr. Autry's testimony, and you've heard the proof about the cell phone records, so you could extrapolate, from that.
You told the jury something. I'm asking you, where was it separated?
Yeah, because in closing, that was one of the issues, is that in closing, and it was Nichols that did the closing arguments, but Nichols made it seem like it was a certainty.
Separated.
You mean a physical location where it was separated?
When and where was the body and cell phone separated?
Well, we believe that when Mr. Autry and Mr. Adams traveled to the river with Miss Bobo, that the cell phone was not there, that she was separate from her cell phone. And we believe that Mr. Dylan Adams was probably the one that had the cell phone thereafter.
Have you gone through and reconciled the timeline Mr. Autry testified as to when he showed up at Shane Austin's house?
Yeah, we did. We spent a good amount of time looking after Mr. Autry gave his account at what evidence corroborated,
Right.
his account.
What time does Autry say he gets to Shane's house?
I can't tell you. You'd have to look at the record there. I can't remember that.
Just take a moment. Did you ever remember somebody saying, wait a minute, we got a problem? Autry and Zach talked that morning at 8:52 a.m., and we've got it on the cell phone record. Yes or
Zoom
no?
in.
We looked at Mr. Autry's records and looked at Mr. Adams' records.
You remember a phone call at 8:52 a.m.?
Not the particular time.
Do you remember if Zach was at his home tower at 8:52 when that phone call went out?
I do not remember.
Do you remember saying, oh no, Holly's cell phone and her body are on 10961? We got a problem.
I do not remember that being a problem.
Do you remember Autry testifying it was 20 to 30 minutes after the 8:52 phone call, which puts it at the very earliest at 9:12, the latest at 9:22, when Autry appears at Adams' house? Do you remember that?
Not the time.
Do you remember if it was at 9:20, if it was at 9:17, 9:15? Autry says Dylan is standing in his shirt off inside the trailer. Do you remember that?
The trailer, do you mean Mr. Austin's house?
Yes, sir.
I don't remember the time, but I remember Mr. Autry describing when he arrived and Mr. Adams being there, Mr. Dylan Adams, without his shirt.
And that time, Holly's cell phone is traveling from 9:10 down to 9:25 at Gooch Creek, which shows somebody's lying.
Well, again, I don't remember the times, but also what we have to take into account when we look at these things is we got different actors, right? So this idea that Mr. Adams, Mr. Autry, Mr. Dylan Adams, and Mr. Shane Austin are together the whole time is just not, that's just not correct.
Right, but you told the jury.
But you put them on the stand anyway, at least Jason Autry. So if you're saying that you don't know that Jason Autry was being truthful, but you chose to put him on the stand, that's a problem.
It was Dylan moving the cell phone when Jason says Dylan is sitting in his trailer with his shirt off and never left.
Again, I don't remember the times, and I think you do have to you have to take into account that we're talking about circles and not pinpoint GPSs. I remember also the expert cell phone testimony having to do with bleed over between Zach's home tower and
No doubt.
one of the other towers.
Right, 31523 and 31522, sometimes you can ping off both. But not 12573 where the phone was found. I'm sorry, where the lunchbox was found and other things. Correct?
I don't remember.
Okay. Now, you did not take part in the Jason Autry proffer session, did you? Or
I
did
did.
you? Okay.
Absolutely.
Did you take notes?
No,
Why not?
I don't take notes.
You don't take notes.
I don't.
You take notes during trial?
I don't.
Okay, fair enough. Was it a policy not to take notes during proffer sessions?
Absolutely not.
So, we talk a lot about in this chat. No notes means nothing discoverable that you need to turn over, nothing that you can reference to be cross-checked on. But secondly, looking at this guy, Mr. Potato Head here on the stand, who doesn't remember anything, you of all people, even if you're trying to make things non-discoverable, you've got nothing stored in here. You should be taking notes for yourself, because you do not know your case.
When, if ever, did a TBI officer come to you and say, I think Jason Autry's lying?
No TBI officer came to me and said that.
Valerie
Are
Trout?
you aware of a TBI officer coming to any prosecutor and saying that?
I'm not. I'm aware of ex-TBI Dicus that I went to talk to, but
What about Kathy Ferguson?
no, I'm not aware of that.
If she did, it would have been significant to you, wouldn't it?
It would have depended on what we're talking about, but it potentially could be significant, yes.
Isn't it always significant?
Now, at some point, did you come to the conclusion, we're going to lose this case if Dylan's our witness?
No, but Miss Nichols and I, like I said, believed that Dylan was leaving a whole lot out and holding back, and we weren't entirely comfortable with him being a primary part of the case. We were much more interested in a cooperator that would tell the truth and give a truthful account of things.
Okay.
So yes.
At some point, did you listen to Brent Booth in Indiana talking with Victor Dinsmore?
I did not.
Okay.
I think Miss Nichols had, and she relayed to me sort of generally.
Did Miss
No.
Nichols bring up concerns to you about that conversation?
I remember this. I do remember that she wasn't impressed with the interview.
On Agent Booth's behalf or Victor Dinsmore's?
Can't remember.
Oh,
Really can't remember. I think that we had higher hopes for like what would be disclosed in the interview, and
so what they're referencing here is like the 3-day span of the Indianapolis trip to go get information from Vincent Dinsmore while saying, hey, there's like 8 charges we could bring against you. And on day 1, they have this longer recording with some specific details. There's a day 2 where apparently Nichols has a conversation with the TBI agents. And then on day 3, they go back and there's a second call. And suddenly, after having a conversation with my wife and my daughter, they jogged my memory and we actually remember these details instead of those other details. And Booth is heard like, well, good, I didn't want to put words in your mouth. So, yes, the old Dennis Benjamin trip with Brent Booth up to Indianapolis. Just a hot mess. So Trial and Error has that on their channel. What episode was that? I think episode 9, Suborning Perjury, is the one with those Vincent Dinsmore recordings. And they've been played throughout the hearings. I think the best place to hear those in the context of the post-conviction hearings was when Kathy Ferguson testified. So, and that was, I think, part 6 of our deep dive. So, links in the description for that. Good times.
That didn't happen.
Have you listened to this since the trial?
No.
Did you listen to it before the trial?
No, I didn't. Like I said, I think I'm going on third party summary of it.
When you say not impressed, I take that to mean you, as a lawyer, you wish it would have been better evidence at trial.
I don't know if we ever contemplated it being evidence at trial, but I remember when he went to interview him, we had high hopes that Dinsmore had more information and we were going to get it as a result of the interview.
Do you remember, did Ms. Nichols say, I'm a little concerned Agent Booth suborned perjury?
No, but not being impressed with the interview, she may, I don't want to guess, she may have made comments about she didn't like the way he asked questions or something like that.
As a prosecutor before trial, do you think it's ethical for you to go to one witness who's going to testify to something, go to another witness and say, look, this is what this witness is going to say, and I'm trying to get these details lined up, and it helped me and it helped this case if you said this?
You don't want to ask for a witness not to tell the truth, right? And you don't want to feed a witness information. A lot of times it is helpful to confront a witness with facts that you do know in hopes that person is then going to tell the truth. So it's a sort of mixed answer there.
Okay. At some point now, who approaches whom? You or Mike Scholl regarding Jason Autry testifying?
So to testify or to sit down and tell us what happened?
Whatever came first.
Okay. So there was another time that we were in Nashville. We went to Nashville several times. The Discovery Conference I mentioned. After the Discovery Conference, at least once, maybe more than once, we met in Nashville to look at the evidence with the defense attorneys. And all the defense attorneys came, and it was an enormous amount of physical evidence and things there at TBI. Again, I can't remember if we only did it once or twice or 3 times, but during one of those meetings, I approached Mr. Paris, who was co-counsel of Mr. Scholl. And I told Mr. Paris that we would be interested in hearing the truth from Mr. Autry. I think I said this, even if he was part of the very worst of it.
Why did you pick Mr. Autry first? I'm sorry, why did you pick Mr. Autry?
We had talked, me and Ms. Nichols, Mr. Christensen, and Mr. Ragland had all talked previous, and like I said, we were relatively, we were convinced that Mr. Dylan Adams wasn't telling us everything, and we believed, or we had hoped that Mr. Autry would be truthful and be able to tell us more.
Why didn't you approach Ms. Thompson?
I can't say that nobody didn't previous to that. I can say that what we were hearing from Ms. Thompson from the start to the end of the case was that Zach was maintaining his innocence.
And had you been aware of any times where Mr. Autry was not?
In terms of court pleadings, I'm certain that he was maintaining his innocence. And then during the trial, he was cross-examined with regard to the times that he had maintained his innocence. There was never a time that I spoke to Mr. Autry and he told me anything different than what you heard at trial.
But if what we heard at trial is that he said two different things, how can that answer be genuine? That's a weird way to say, yes, Mr. Autry told me different things. How does that compute?
With regard to the times that he had maintained his innocence. There was never a time that I spoke to Mr. Autry and he told me anything different than what you heard at trial.
Y'all were still seeking the death penalty for Mr. Autry
At what point?
when you and Mr. Scholl were talking?
Yes,
Okay. Now,
Mr. Paris, but.
Mr. Paris, how many cases have you had with Mr. Paris where he represented what would become a cooperative witness?
I can't say for certain. If you told me that we had had 3 or 4, I could believe it. If you've told me that we never had one, but we've definitely had cases together, that could be true. I can't remember if we've ever had a cooperator before.
Same question regarding Mr. Scholl.
Since then, I know I've had at least one with Mr. Scholl.
Prior to this, prior to the 2016,
After 2016, I know that we've had one. Before 2016, I assume that we've had at least 2 or 3 or 4, but I couldn't name a name, and if we look down at every single case I prosecuted and we could only find one, that wouldn't shock me.
Right.
But I think we've definitely had cooperators before. And I'm talking about serious cases. He also handles, cases every day in Memphis. 3 guys steal a car. We very well could have numerous cooperators on cases like that.
he is a good attorney in Memphis,
I consider him a very good attorney, yes.
and he handles a lot of high crimes, low crimes, and everything in between.
Sure.
And do you have his cell phone, you text each other,
I have his cell phone, yes.
and consider him a professional friend.
I do,
Miss Nichols did as well.
yes.
Would you say he is less hostile than, say, Miss Thompson was in this process?
So,
Say yes.
Mr. Scholl is a very good attorney, and different attorneys have different styles, right? At the end of the day, if it's going to help his client, Mr. Scholl's going to fight, tooth and nail. Ms. Thompson is a very good attorney too, and I got along, quite well with her, I think.
Miss Nichols did not.
There was a little oil and water, or whatever you call it, there.
What did Miss Nichols say about Miss Thompson?
Objection, Your Honor, hearsay.
I'll strike that.
All right. Objection sustained.
What did you observe in their interactions?
So I got to play sort of a role that, I was comfortable with, which was like I got along with Ms. Thompson quite well. So she knew she could come to me with, questions or, like I need X or I need Y, or I want to talk about, X or Y. I think that she definitely, as I said, and this is not to her discredit, but she was at the extreme maintaining Zach's innocence, and she vigorously litigated, and she was sometimes met with sort of vigorous litigation, on the other side, but it was,
You and Mr. Scholl never discussed what Mr. Autry was going to get in terms of a sentence prior to his testimony. Is that your position?
That's true.
All right. We'll ask you, just, do you understand the difference between express and implied?
Yes.
All right. Express is some words to that exact effect, correct?
Okay.
Implied is something that's not reduced to words.
Okay.
Was there an implied understanding with Mr. Scholl?
There was an express understanding that that his truthful testimony would be taken into consideration.
I'm aware of the party line. My question is,
Can I object to the characterization?
I'll strike that.
That's not at all what Mr.
I'll
Hagerman
strike this.
testified to.
what was the implied understanding?
The implied understanding is the same as the express understanding, that your truthful testimony will be taken into consideration. What you also have to balance against this is what was the case we had against Jason.
This is critical because this is exactly why, and it's not just limited to this case. I've seen it in other cases where you imply that there's going to be some leniency, but you withhold the official deal making. Or even if you solidify the deal, you withhold the sentencing date until after the testimony is delivered at trial, because that keeps the pressure on the individual to quote unquote testify truthfully. One of my favorite examples, and I hope I have it ready to go, in the YSL trial, the way the language was written on these plea deals, they had several witnesses in the YSL trial that were indicted, but they took pleas, and some were Alford, but those that weren't, they had to sign off on certain factual acknowledgments, namely being that they had knowledge that YSL was a gang and not just a music label, and some other things. But the language was, defendant cannot truthfully assert that anyone charged in this indictment is not guilty of the crimes as alleged in this indictment. The defendant will make no attempt at trial, prior to trial, or after trial to exonerate or exculpate anyone charged in this indictment of the crimes alleged in this indictment. Defendant will not claim that anyone in this indictment is not guilty of the crimes as charged in this indictment. So, the theory being, if you are signing off on these factual acknowledgments, there should be no reason that you would be saying at trial on the stand under oath something to the contrary, that, hey, I signed this plea agreement that this is a gang, and now I'm going to get up on the stand and say it's not a gang, those guys are innocent. But this type of phraseology, we'll call it, puts the pressure on. You have to stick to the story that you proffered to the state. And a paragraph like this doesn't give room for change. It doesn't give room for you to, hey, if you have new information where you change what you think you know, you're then permitted to say what you think presently. And it's the prosecutor's role. They can decide to charge you with perjury. A very enlightening ex parte meeting that caused a lot of kerfuffle in the YSL trial involving Kenneth Copeland, Woody, meeting in chambers. His attorney had a scheduling conflict, wasn't available. So there was a stand-in attorney, Kayla Bumpus, and defense attorneys find out about this ex parte meeting and that Kenneth Copeland was asking, well, what if I get on the stand and I say I'm the one who murdered Donovan Thomas? And the prosecution in chambers kept telling him, well, the only thing you can't go up there and do is commit perjury, because we can charge you with that. So these types of plea deals, whether you're withholding the sentencing or you're saying, hey, we'll work something out with you, but it's not quite yet on paper. The express promise of leniency, the implicit promise of leniency, and a forthcoming deal, but we'll see how it goes at trial. We'll see how you do at trial. You can't successfully cross-examine on that. Even if Jennifer Thompson, we've observed and we've been looking for these issues with ineffective assistance of counsel, how do you effectively cross-examine on that? I think the jurors in the YSL trial listened very intently, and because they also sought over and over, witness after witness being pulled from Fulton County's Rice Street Jail to come and testify. Or if they didn't testify, they would be thrown in Rice Street for the weekend. They got to see it over and over. But in the ordinary course of business, ordinary trials, I think most jurors are going to sit there and think, why would somebody lie? Why would somebody say they were guilty if they weren't actually guilty? And even the best cross-examination can't always overcome that. So,
And Autry at the time. And so that informed, a lot in our mind about what, ultimately is going to happen probably.
Well, let's go through what was the case at the time. You had Dylan Adams providing a statement that if the cell phone records were accurate, Dylan Adams' statement was inaccurate.
We had Dylan Adams wanting to be a witness and had given a statement.
I should clarify one more thing. So the plea deal snippet that we were reading was actually from Chontavia Stevens in the YSL trial, and that paragraph was present for several that took pleas. Kenneth Copeland wasn't part of that indictment. He was initially, they were looking to charge him initially and 3 others with the murder of Donovan Thomas, but then they changed along the way who they attributed to that crime. So when it was time for Kenneth Copeland to testify, there wasn't like a confrontation issue because he wasn't charged. But when he was on the stand, we found out through the cross-examination of Max Shart that there was a separate charge hanging over Kenneth Copeland's head. And the prosecutors had been going and meeting with him. Simone Hilton was meeting with him outside of court. Adrian Love was coming to talk to him in conference rooms. And we find out that they null-prossed, or they like withheld prosecution on a different charge he picked up while incarcerated. So a separate mechanism to get some type of leverage, put pressure on, like, tell your story the way we want you to tell it. And they didn't tell him that they made that decision until after he'd already started to testify in the YSL trial. In fact, I think he said he didn't find out until Max Shart showed him. Attorney Max Shart showed him live on the stand. So
Dylan's statement, unlike Jason Autry's statement, went through what happened the night before, right?
I think I remember that.
And and if those statements are true, the cell phone records, they're inconsistent with the cell phone records.
I would think so.
Dylan Adams went through start to finish the night before through several days, correct?
I remember his statement being a lot more piecemeal and a lot more sort of labored, but I do remember they definitely did talk about the time period before, and I'm sure that his statement, again, much more piecemeal, I'm sure his statement extends past the crime.
And now you say Autry, you said Dylan's statement left things out, but Dylan's statement chronologically covered a far longer time.
Again, having watched Dylan's statement and having talked to Dylan, it was not like you were getting an account that went from point A to point D or E or whatever. This thing is broken up, staccato, like hard to...
Didn't make sense.
Excuse me?
Didn't make sense, did it?
It definitely left so many questions, and it left us with the sense that he was not telling the whole story.
At what point did y'all say, all right, why don't we take the death penalty off the table since our main witness, his story doesn't make sense?
I don't know that Dylan was our main witness. When I came into this case, we had the 3 defendants, that remained, and who was going to cooperate, if anybody, was still sort of an open question. There was sort of an assumption that Dylan was, quote unquote, the state's witness, but nobody had committed to that or anything like that.
So was the state prepared to request Mr. Autry serve 50 years? When Mr. Scholl and you were discussing Mr. Paris, y'all very well could have asked for 50 years.
I don't know, Jack, this calls for speculation.
It goes right to the
Throw
heart
out
of,
numbers.
this is a pled allegation in our complaint.
Which is what?
Which is that the state did not disclose this, what became reality, but the difference between offers of leniency and 8 years' time served.
Anything else, Ms. Wyler?
No.
All right. Objections over, we'll allow the question.
I think this is important for two claims, right? Because if it's something that Jennifer Thompson should have known about and she failed to cross-examine on these specifics of something coming to fruition in the future, then technically it'd be ineffective assistance of counsel. To me, this is more like prosecutorial misconduct, not disclosing offers of leniency, is the more obvious issue.
Did the state have internal discussions about what it would be willing to do to Mr. Autry?
Internal. Me and Ms. Nichols and Mr. Christensen, Mr. Ragland. Yes.
And what were y'all prepared to do?
Well, after we heard Mr. Autry's account and after we saw the corroborating evidence, we believed that Mr. Autry was telling the truth. On the other side of the equation was that the state's case against Mr. Autry was quite weak at that time. And so Ms. Nichols and I and Mr. Ragland and Mr. Christensen all talked and knew that at the end of the day, we were obligated to take into account that the state's case against Mr. Autry was quite weak and that his account was the most truthful, most detailed, and most corroborated account of what happened and assisted in the prosecution of this defendant, Mr. Dylan Adams, more than sort of any other single piece of evidence we had. And so we knew that meant that Mr. Autry, at the end of the day, again, this wasn't communicated to defense, but at the end of the day, we weren't going to get much more time out of Mr. Autry.
Then time served.
I can't say that we talked about time served. I can absolutely say that we talked in terms of we're not going to be able to get much more time out of him.
Okay. Was that ever communicated to Ms. Thompson?
Those internal thoughts that we had?
Yes.
No.
Why not?
What was communicated to Mr. Thompson was that the truthful testimony of Mr. Autry was going to be taken into consideration at the end of the day.
But y'all held the keys to the secret, which meant that means time, virtually very little more jail time.
We knew that that was what we had against Mr. Autry was, here, and what Mr. Autry was providing for us was here. And so we talked about these things internally because we have to make a decision as to whether or not to use Mr. Autry as a witness, or not. So obviously we have to talk about these things. We would never convey that to Mr. Autry or to Mr. Scholl or Mr. Paris without telling the defense and the court, because that's what we have to do, because that would go to motive and bias. Since these were internal discussions, it couldn't possibly go to any sort of motive to lie or any sort of bias. At the end of the day, we have to do what's fair. His truthful testimony deserves some credit. At the time we made the decision, our case against Mr. Autry was very weak.
Do you remember attending the plea hearing of Mr. Autry?
Yes.
Yeah, he did the colloquy.
Just about time, I hate to interrupt you, but I'm going to. It's a little after 12. Is this a new topic you're going to get into?
Somewhat,
Is
yes.
this a good breaking point?
Good breaking point.
It's going to be 10 minutes or less. I'll let you finish.
It's a fine breaking point, Your Honor.
Okay. All right, ladies and gentlemen, we're going to recess for lunch today. We'll be ready back and start at 1 o'clock.
Yes, sir.
Ms. Bates.
Yes, sir.
All right, Mr. Hagerman.
Yes, sir.
We probably have to have lunch alone today.
Okay.
You're not allowed to discuss this case on the state's side or anything else, all right?
So if I get to the Italian place first, then can we go?
I think we're in recess till 1 o'clock.
All rise.
All right, we're going to time travel. I think Trial and Error cut this break out already, but not without first thanking Slim Life NJ for the super chat. It says, happy Monday all. And it's also December 1st. Holy moly. Thank you, Kat, for the amazing coverage. Thanks for hanging out. You are the best. Have a blessed day. A simple hello and a smile can make someone's day. That's some bars right there. That is some bars. So big thank you to Slim Life NJ. Make sure you guys were all saying hello. hello to Slim Life and everyone that comes into the chat to hang out with us. And I'm also, I think when I scheduled, because we're going to watch the rest of day 7, the trial day, but I'm going to do it as a separate stream. That way I can keep the trial 2017 trial rewatch together and the post-conviction proceedings in their own playlist. So I'm going to redirect us over there after we get through this full testimony. We still have like an hour and change to go, like an hour and 45 minutes. When I set that stream up in StreamYard, I think it... Okay, wait. I think I'm getting comments again. I had 2 StreamYard windows open and it stopped giving me comments over here, but now I see them. So, destined to be happy birthday all month of December. So now I'm seeing these. I was going to say I was going to refresh, but we don't need to. We can just keep going.
When you're still on up. Mr. Bates, you may continue.
Thank you, Your Honor. The trial was in 2017 of Mr. Adams, correct? And Mr. Autry pled out on September 14th, 2020. And it was in this courtroom.
Yes.
What were the discussions with any representative of Mr. Autry regarding his plea between the trial and 2020 when he pled out?
Not many. After the trial, I can't tell you if it was 60 days after, or 3 or 4 or 5 or 6, months after. But definitely within, I would say, about a 6-month time period. We communicated to Mr. Scholl and Mr. Paris. I don't remember which one. I don't remember if it was. I don't remember if it was me or Ms. Nichols. I don't remember exactly when Ms. Nichols got off the case. Okay, but either me or Ms. Nichols communicated to Mr. Scholl and Mr. Paris that Autry needed to wait, that we wanted to resolve Dylan Adams' case. I don't remember if there was talk about what a guilty plea would look like, or if it was just you need to wait for Mr. Dylan Adams' case.
When was Dylan Adams' case resolved?
The record's going to have to reflect that. I don't remember.
Exhibit 13.
Do I have? I have it.
Yes, sir.
January of 18.
Okay. So it's over 2 full years, almost 2.5 years from that time to the September 14th, 2020. Would you agree that the Mr. Zach Adams' motion for new trial was resolved in the summer of 2020?
That sounds right. I think that would be the last thing that we were waiting for.
Why were you waiting on the motion for new trial then?
I'm not sure exactly why, but I do remember that after Mr.
Come on.
Dylan Adams pled guilty, that we did communicate, and I say we again, I don't remember if it was me or Ms. Nichols, I don't remember if it was Mr. Paris or Mr. Scholl, but we were going to wait until Zach's case was entirely resolved as well.
Why?
I'm not sure there's a legal reason from our perspective, and I don't really consider it gamesmanship, but we wanted Mr. Autry in custody for as long as we felt we could keep him.
You mentioned the word
But you gave him-
gamesmanship. Define that word.
Well, I mean, I think that we needed to be fair to Mr. Autry, take into account how helpful and truthful his cooperation was. At the same time, what the state of our case was with regard to him at the time. So we needed to make him a fair offer. And to me and Ms. Nichols and the other prosecutors, we knew that meant we couldn't keep him in jail much longer. But he was part of this. He has a bad record, a bad criminal history. We were interested in keeping him in jail for sort of as long as was fair.
Were you in court in Decatur County on February the 1st, 2017 in this case?
I couldn't tell you. I've definitely been to Decatur County on this case.
Do you remember what Mr. Scholl saying that he made a phone call to the court and I told Your Honor that we would not...
Objection, Your Honor, to the hearsay?
I'm asking if the court witness remembers this. This is an official proceeding in court.
Okay, but what's,
Hearsay.
I understand, what's the relevance here?
I'm impeaching the state's position that there was nothing to disclose under Brady regarding Mr. Autry's eventual plea.
This occurred in 2017
Yes, in motions.
in Decatur County.
In Decatur, before the change of venue, on a motion date.
Okay, so did the other matters not change venue to here? Mr. Adams already had?
It's
Mr.
pro...
Zach Adams already had?
No, Your Honor. They were all, the motions were still being heard in Decatur County. The trial
It was
eventually got...
2017 when it was before the trial.
Yes, Your Honor.
All right, I'm gonna allow a question. That's all.
Yes, sir.
Objection over.
You remember Mr. Scholl saying, he had a second phone call to the judge, I told Your Honor that we would not be in trial. Do you remember him saying, I let the court know we're not going to need a trial date?
I don't remember that, but absolutely he would have, because it was clear at that point, if I'm getting the dates right, that we're proceeding to trial on Zach Adams and Mr. Autry is going to be a witness.
Do you remember him also asking, now this is in February of 2017,
Thank you for the
I
5
gave you
gifted
2 phone
ABE.
calls, one of which was to ask what the procedure was to enter a plea agreement in Your Honor's court for approval. And then I told you I would notify Your Honor if we had felt that we were not going to be in trial. Do you have any explanation for why prior to trial Mr. Scholl was asking about a plea agreement?
Well, I assume we're at the point where Mr. Autry, you have to look at the dates of Mr. Autry's proffer, but I assume we're at the point where Mr. Autry is proffered.
Oh,
We've met with Mr. Autry a couple times. We've decided
Thank
that we're
yous.
going to trial with Mr. Zach Adams. We're hearing motions, pretrial motions on Mr. Zach Adams' case. Mr. Scholl's informing the court that his defendant will not be going to trial, but instead, I don't know if you said, will be testifying.
Well, if no formal agreement had been reached to communicated in any way to Mr. Scholl, how did he know his client wasn't going to trial?
Oh, we would have told him his client wasn't going to trial with regard to Mr. Adams' case.
Regarding Mr. Autry's case.
Oh, well, that was his decision at the end of the day. So we couldn't tell Mr. Scholl his client was never going to trial.
Had you communicated in implied ways, we're not going to ask a lot of time for you.
No, we had not.
When you used a word that Mr. Scholl and Mr. Autry would have to wait, and will you agree with me, to wait means to wait for something you anticipate or expect?
Sure.
Well, what were they waiting on for Dylan's case and Zach's motion for new trial?
Well, Mr. Autry would have been a witness against Mr. Dylan Adams had that gone to trial. So
Right.
they'd be waiting for Mr. Dylan's Adams trial.
January 2018. You communicated, some point after that, you communicated you still have to wait for the motion for new trial to be resolved.
That's right.
Wait on what?
For the motion of the trial to be resolved. I'm not saying there's a legal reason.
And what was,
oh my
well, everything
gosh.
you do has a legal reason.
Well, we wanted to wrap these cases up, at the same time, and so we needed to get Mr. Zach Adams done, Mr. Dylan Adams done, at the very end of the day, Mr. Autry done. And as, a byproduct of that, Mr. Autry was, in custody, which we saw as a good thing.
But then you
What
gave him 8
was
years, mostly
Mr.
served.
Autry waiting on
Well, first, Mr. Dylan Adams' resolution, and then
from the
Mr.
state?
I understand what you're saying.
You told Mr. Autry you'll have to wait.
He'd be waiting for an offer
Okay.
that he could then accept or not accept.
Well, why 3 years before his plea date, his attorney saying, we're not going to need a trial for Mr. Autry?
Because he knew that he was cooperating, and I think, he hoped that his truthful cooperation, like he was told, would be taken in consideration, and that would resolve his case.
Yep, remember, we watched that clip yesterday, and I clipped it separately on the video. It's like a 20-minute video. I'll drop it in the chat in a second. But the judge at that hearing, before they go on the record, is out in the gallery speaking with Karen and Dana Bobo. Then he gets up on the bench, and he's like, well, we're not going to need a trial date. I don't know exactly what the conversations were. How do you know you don't need a trial date? How do you know you don't need a trial date? And then when the plea colloquy starts and Paul Hagerman's the one doing the colloquy for the state, he says something to the effect of, it's 3 years to the date. He helped us, his testimony helped us with the Zachary Adams trial. And the judge pauses him to say it was like the most credible and compelling testimony he'd ever seen. Good times all around.
And the state at some point had come to the conclusion it was going to be a plea of time served.
Internally, we had talked, and wrestled with it, and, sort of came to the unfortunate conclusion that what was fair was not much more time for Mr. Autry. That's how we talked about it.
And that was never disclosed to the jury.
No, that was not disclosed to the jury, not disclosed to Mr. Autry or Mr. Scholl or anybody. You asked about internal and conversations. Those were absolutely between Ms. Nichols and me and the prosecution team.
How many cases have you had Mr. Scholl represent a cooperating witness, and his client received more than time served?
Well, I know at least one, because I just had a case with Mr. Scholl and his cooperators doing 20 years, going to get 20 years. I think you asked before how many times I had a case with Mr. Scholl cooperated, and talking about major cases. I told you it could have been 0 or 1, or it could have been 3 or 4. I just don't remember, so I just can't remember.
Now, let's kind of delve a little bit into criminal work. The defense lawyer offers happen all the time in criminal law, correct?
Absolutely.
And at some point, a prosecutor, you trust a defense lawyer.
I mean, some you trust, some you don't trust, right?
Right.
Yeah.
Mr. Scholl's in that trust list for you.
Yeah, he is.
And you would agree this is a huge case.
Yes.
Defense lawyers on an appointed case don't make a lot of money.
I really don't know. And this is a capital case too, so.
Okay.
Yeah.
Did it occur to you, Mr. Scholl has every reason to plea out Mr. Autry and avoid a 2-week trial? Remember, his motion to continue in August of 16 says, holy smokes, I'm overwhelmed. Did it occur to you, maybe he wants out of this case also?
You probably could have taken a poll and everybody wanted out of this case. This was a lot of work, right? No, I don't think that factored in at all. I know Mr. Scholl, and he's going to try to do what's best for his client. And if he's in trial for 2 weeks or even a month, I know he's had federal trials that extend and extend, then he's going to do it.
All right. Now, I'm going to read from the transcript. Your Honor, I have a marked up version. It was attached as Exhibit 6, I believe, to our petition.
To your petition,
To the amended.
been entered as an exhibit to this hearing?
It is not, and my version has a marked up copy.
Which amended petition? Oh, yeah.
It was pre-labeled Exhibit 6 because our copy is the copy before the court. And there's markings that I can what I made and has made copies of.
So are you going to enter it now?
Yes, Your Honor.
You saying we need to disregard the markings? Or
Yes.
are you going to give us a clean copy after the break?
I can give a clean copy. It probably won't be today.
Tomorrow.
We'll get that.
State's okay if we get a clean copy of this tomorrow?
Yes, sir.
All right, tell me again what it is.
It's a transcript of Jason Autry's guilty plea, September 14th, 2020.
9/14/20?
Yes, Your Honor.
You passing it up to the witness?
Yes, Your Honor.
We'll mark it as exhibit 105, is that correct? 106. What do we do with 105?
IR 2900.
And can you go to page 12? And on line 19, you see that Mr. Scholl stipulated the factual basis existed for the plea and asked to accept the negotiated plea.
Yes, sir.
Let me go. Sorry, go to page 6. Go back to that. Where you said on line 24, page 6, I will talk as loud as I can. Actually, 3 years ago to this day, Mr. Autry testified in this courtroom and told the jury, and I guess the world, as it were, what happened April 13th, 2011. Now, you agree that Mr. Autry did not say he raped Holly Bobo.
That's correct.
That's an important part of his testimony.
He did not say that, yes.
You agree that is an important part of his testimony.
I mean, yes, that's an important part of his testimony.
And if he was lying about that point, it'd be significant.
Be significant.
His version of the facts that day, he shows up, Miss Bobo's wrapped in a quilt or blanket, drives to the river, she moves, Zach shoots her, drives back, Jason then goes to lunch in Benton County.
At the health department, maybe.
And do you remember what the other 3 defendants did that day after that, according to this story?
According to I think Jason departs from the other defendants.
Right. Do you know what evidence there is as to what the other defendants did?
I believe they're seen either at the Dinsmores or having something to do with the Dinsmores.
Okay.
And I know that there's a situation at Zach's, or maybe Dick Adams' house later that day where 911 is called. That's what I remember. That's what I remember.
All right. And on line 9, you're talking about the Bobos in support of this agreement. And you say, which takes into account the realities of the prosecution before Mr. Autry cooperated, and then takes into account the importance of his cooperation and his credible, truthful testimony at trial.
Yes, sir.
And what do you mean the realities of?
This is what I described before, the status of our case against Mr. Autry at the time.
You never once recommended the death penalty be removed from Mr. Autry until his proffer, correct?
This case was noticed as a death penalty case.
Right.
Mr. Zach Adams was the only one going to trial.
Prior to the proffer, they were all going to trial. You agree with that, right?
Well, we had hoped to secure a cooperator so they wouldn't all go to trial, but they were all pending the court and ultimately pending a trial or a plea.
And if they didn't cooperate, you're going to try to put them to death.
That's not how I'd put it.
How would you put it?
Yeah. We had the evidence that we had. We have to prosecute. We have to do the right thing, and we have to be fair. So even with Mr. Adams, who was maintaining his evidence, but there was a mountain of evidence against him, and the cooperation of Mr. Autry. Even with Mr. Adams, we made him offers pretrial, not to quote unquote put him to death. Our job was to do what's fair and do what's right.
But the trial had the death penalty.
Yes.
Then you heard the court say, I addressed earlier at the motion for new trial on the co-defendant, his testimony was some of the most credible, persuasive testimony I've ever heard given in a courtroom. Then you say it answered many questions that were left open factually in the investigation. What were those questions?
Who killed Miss Bobo? Who fired the weapon? I think it also led us to discovery of a potential murder weapon. It explained the whereabouts of Zach Adams and Jason Autry that morning in terms of going to the river and things. So where this happened, how long she was alive for, whether or not she suffered, and what happened to her before she was killed. A lot of important stuff.
You agree Dillon provided more chronological evidence, a more chronologically complete story.
No, I wouldn't agree with that. Like I said before, I thought his story, to the extent it was even a story, was very broken. It was withholding things that he would have had to have known. The interview itself is a lot of the investigators talking sort of staccato, and I don't think it answered many of those questions at all, and I don't think it presented a compelling sort of timeline for how things happened.
What physical evidence connects Jason Autry's story with Holly Bobo being present?
Jason Autry's story with Holly. So you're asking for physical evidence. Rephrase it for me, so let me understand what you're saying.
What physical evidence connects Jason Autry's recollection of that day to Holly Bobo being present?
Being present where?
Where Jason said she was.
Okay. So the phone records of Mr. Autry and Mr. Adams put them together with this trip to the river and back. So that corroborates Mr. Autry's, account.
Physical
But how do we know
evidence.
Holly was there? Because Holly's phone is at 9:25 at Gooch Creek.
Yeah, we do believe that she was separated from her phone.
When and where? Did you come up with an answer at lunch?
Oh!
At some point after the abduction and before they traveled to the river.
What evidence
Doug Bates.
that Jason says from Holly's remains makes his story true?
Well, he talks about the shot to the head, and we have the skull with the shot to the head. We have a potential murder weapon that was found.
That evidence was provided to Mr. Autry.
I don't understand.
The skull was found in September of 2014, correct?
I'll trust you on the date, but about
6
3 years later or so,
So we knew there was a defect in the skull.
when it was found.
So Mr. Autry would have known that.
Well, he also would have known because he saw him shoot her in the head.
So what other evidence confirms that Jason Autry didn't just recall his day?
Well, I think there's some real important, that's things we asked ourselves. Those are real important things. Are there truth tests of Mr. Autry's account? Beyond sort of the obvious corroboration of things like the shot to the head, there's a couple of things that really stuck out to me. Mr. Autry, in his proffer and later at the trial, stated that where the rape occurred, which was over by Shane's grandmother's house, I believe, if I've got the relative right, in a barn-like structure, that they were startled or whatever by somebody mowing grass.
Brian,
These are all the details. This is the Brian Vitt. So Brian Vitt gives a statement. I was mowing the lawn that morning. And it's in the discovery folder that Jason Autry has available to him. And now, in December of 2023, Jason Autry has said he sat there for 3 days after his attorney Matt Scholl said, hey, look, we can make this thing happen. We could get you out of here. Hinting that a deal was available, even though Paul Hagerman doesn't want to concede that there were any conversations that weren't internal to the DA's office about an offer of leniency. And bam, right there, Brian Vitt, I mowed the lawn that morning. So he's recalling these details that are in the same discovery folder that Autry had available to him to put his story together. Well, his truthful testimony matched the evidence. Well, no duh. Jason Autry told us how he took the ingredients and baked the cake together. Yeah. These freeze frames, man, they've been great. Also, big shout out here. Thank you to Amy E for gifting the 5. But I also have now learned that Amy and Classy have started a commentary-free trial stream channel. So that's called Jury of Your Peers. That's in the description now, but it's also dropped in the chat if you're watching live with us and want to hop over there quick and hit subscribe. Great. I'm assuming with the way that Amy E is so good at grabbing body cam footage, I can only imagine it's going to turn into a super awesome archive of trial footage. So just so you guys know that channel has been launched, Jury of Your Peers. Go over there and hit subscribe. And then we have Tay Biz in the building, who, are you like semi-retired right now? We miss you. So Tay Biz has been doing coverage on the Mickey Steins case, Mark Sanchez, and a ton more. But he also works, I believe, full-time. So not an easy thing to work full-time and try to get the YouTube stuff going. Because the second you get real busy with work, that's when something crazy happens with the case every time. But let's show Tay Biz some support. Keep him motivated to keep his content going, because he's one of my favorite people to listen to break down tough cases, tough conversations like Mickey Steins and possible sexual coercion in Letcher County with parolees and their parole officers, which is never a dynamic, never something that should be happening. So tough conversations over there that he gives the information and really insightful breakdowns on. So wanted to give him a shout out and thank you for being a member for 15 months. Holy moly. That's like almost as long as this channel's existed. And he says, I'm not retired. Took some vacation time recently. Congrats, you deserve it. Needed it for my own mental, that's all. It's been a lot lately. I'm glad you got some time. Hope you are doing well, Tay Biz. And Amy E, her channel is Love Amy E. Let me drop the link to her channel for the body cam footage. And that's also in the description as well. But it's great because Amy E will upload the footage, like the raw footage, but she'll premiere each video with the chat feature. That way you can go and react through the chat room feature without any commentary over the footage itself. So great stuff going on over there. And yeah, this freeze frame. Me when I'm thinking.
Vitt's
You're
IR was
pretending
in
to.
discovery that Mr. Autry had access to. It never dawned on you, wait a minute, this guy is recalling somebody mowing his yard in the morning? Did it ever say, wait a minute?
And then you take another detail, like, and I may
So
have...
the answer is no.
Excuse me?
The answer is no. It never dawned on you. Maybe Mr. Autry just read the IR about Brian Vitt mowing his yard, and he's weaved that into his story.
We had a pretty healthy skepticism of Mr. Autry going in, and then when he sat with us and told his account that stayed the same every single time, we dug through everything, looked for corroboration. Every place we saw was corroborated. The phone records, like you said, Mr. Vitt or Witt, I can't remember.
VITT.
VITT.
Brian Vitt.
Yeah. Brenda O'Brien.
Why do we remember this better than this guy? Why do we know his case better than he knows it? I'm not even saying Doug knows this case more than I would expect. He's like superhuman with his knowledge of this case, considering, he didn't work it from the beginning. But us in the chat, we know these details better than this prosecutor knows them. And maybe that's intentional. Maybe that's by design. But what are we doing? We have no idea what we want to know until we hear something that's going to let it be so we can put someone on the stand, they can tell a convincing story to the jury, and we're going to score a conviction whether the details check out with the physical evidence or not. It doesn't matter if it's inconsistent. And that's the end of my quick rant there. Shout out to Tay Biz for the super sticker here. Says you're amazing. Right back at ya. Right back at ya, Tay Biz.
She's, I don't know how you dig through 4.2 terabytes and find the little tip to TBI that's one of like 25,000 tips about a woman that calls in about a man, trying to fish on the property, but he's actually looking for, the remains. There's some real sort of truth tests, I think, in the facts that he lays out.
All of which was
He didn't tell you any of that until he had his discovery folder. He never independently told you any of those things until he had it somewhere else.
exchanged in discovery.
The murder weapon, no, because
Okay.
obviously he gave
All
us
right. Well, let's go to the
information
murder
with
weapon.
regard to
Mr.
that.
Hagerman could finish his answers.
I apologize.
Talks over him.
I interrupted you and I
It's
said.
okay, it's okay.
Okay. Are you aware the story of how this gun becomes, what your words, the murder weapon?
I believe so.
All right. What's the first gun that Victor Dinsmore said he purchased with drugs from Shane Austin?
I can't remember that.
You know the only gun Victor Dinsmore initially said he purchased?
No, I can't remember that.
Okay. What did Jason Autry say was the gun that he saw on Shane Austin's holster initially?
You have to trial transcript. I can't remember
All
that.
right. 357. You remember that?
I'll take your word for it.
All right.
It sounds familiar
Bold man.
because I do remember the weapon looking like a 357.
Then do you remember, after that, Victor Dinsmore telling Brent Booth, I'm 100% certain I know my guns. I bought from Shane Austin a .38 revolver with a .357 interchangeable barrel.
I don't remember that.
You also remember Mr. Dinsmore saying, my wife had a .32 revolver that she threw away.
I don't remember that.
You remember 6 days later, the murder weapon was found, quote unquote murder weapon, it was a .32 revolver.
I remember the gun being found.
Do you ever remember saying, time out? Initially, it was supposed to be a .22 rifle. Then it became a .357. Then it was a .38 revolver with a .357 interchangeable barrel. And the same man, Mr. Dinsmore, acknowledged that they had thrown out a .32 revolver prior. Did you remember saying, time out? Folks, the .32 revolver is just the gun that his wife threw out. We're being played.
So what I remember is Mr. Autry's description of the gun as far as what it looked like. And when this thing was found,
What was the
that's what it looked
description,
like.
sir?
I remember that. I don't remember Mr. Dinsmore's statements about guns or that gun. I do remember the search for the gun on the side of that little road there. And I remember ultimately it was found, continuance granted at trial, it was tested with regard to forensically.
And at any point along the way, nobody from the state thought, we need to know what the size of a .380 auto round is that was found next to the remains.
Yeah, again, my testimony is the same on that. I just don't remember. I do remember there being a casing.
Any physical evidence from Holly Bobo that corroborates Jason Autry's story?
So I believe that you have items that are found in proximity.
He's coming back to a question that he asked probably 20-something minutes ago. And we're getting a, I believe.
To Mr. Austin and Mr. Dinsmore's, where they lived. Is it Sulphur Springs? Is that
Right, but
the
The
right
items in the
word?
road.
Right street?
you're familiar with Marshall Walker's story that there was no physical evidence thrown out. He was tragically killed off Tower 10961. Physical evidence thrown out along the clockwise route that ended at Gooch Creek where the lunchbox was.
I remember there was items found
Right.
in proximity to Mr. Austin or I think they lived close, Mr. Dinsmore's house. I think that street may be Sulphur Springs or near Sulphur Springs. I remember there being more property found, in my mind, south of that, which is probably Gooch Road.
And I want to put this out there for anyone that missed the testimony about the panties, the underwear that were recovered from the road 75 feet away from Shane Austin's house. So this is a guy, I forget his witness, just a civilian witness, noticed in the road this pair of underwear, called it in, Brent Booth shows up, and then while he's waiting there with Brent Booth for more people to come and look for the evidence, several feet away from, like 50 feet away from where the underwear found, but still in proximity to Shane's house, is where they find like this crumpled up piece of paper that's some type of like drug note from Holly Bobo. But doesn't find that until after Brent Booth gets there. Now, hear all of this about the underwear, the pink underwear. Even Dylan Adams says something about pink underwear. In his truthful, badgering interrogation with Booth and Jackson. And then we find out, now that we're rewatching the 2017 trial, there's a quiet little mention in the trial that the DNA in those underwear belongs to somebody else. There's nothing tying that pair of underwear to Holly Bobo. But we keep hearing about physical evidence found near Shane Austin's trailer. Like, what are we doing? And why was the discussion of underwear said out loud so many times during the 2017 trial? And now, presently, this is November 2025 at the post-conviction hearings, Hagerman has no idea what physical evidence ties these guys to Holly Bobo. But he's mentioning the belongings once again.
I remember us believing that is Dylan disposing of property, while Zach and Jason go out to the river. Or the time frame may not be exactly right, but something like
Right, but that route of Dylan's is timed. And are you aware that Jason Autry's testimony was Dylan at no earlier than 9:12 and up through 9:22 is his shirt off at Shane's trailer. So it's impossible for two things to be true.
Well, again, I don't remember a strict timeline for Mr. Autry's testimony. So you say 9:12 to 9:22. I can't say that I remember that. And I can also tell you that, we had, if you count Mr. Walker, you had 3 quote-unquote cell phone experts testify at trial, and the other 2, the one for the state and for the defense, explained that what we weren't looking at are GPS hits that we have any sort of confidence in with strict timing or location, that we're talking circles and time periods.
I agree. There was evidence found along this route with the pings consistent with the direction of travel south, correct?
That's how I remember it.
All right. Now, and if Mr. Autry had in fact raped Holly Bobo, you would agree his entire story is made up.
No, I wouldn't agree with that.
What? How? Because he shows up, the body's rolled up, they're not at Shane's house very long based on the cell records, and they go to the river.
Yeah, no, I think, we encounter, I'm not saying this is the case with Mr. Autry, but we encounter defendants all the time who tell the start and maybe the end, but leave out things in the middle that look real bad for them.
And of those times, how many times when you plea him out do you say, he told the jury and I guess the world, as it were, what happened April 13th, 2011?
Yeah, like I said, I don't believe Mr. Autry did leave that out, but you asked me about defendants, and
Okay, but the point is, you didn't take the position that, well, his statements were probably 40% true. They were just enough.
What Doug's arguing is, in closing, they rely on Jason Autry as if he told, like, the full A to Z story. Closed all the gaps, answered all the questions, left no stone unturned. Meanwhile, outside the presence of the jury, the prosecution knew there were troubling things about Jason Autry's testimony. That he didn't want to get on the stand and commit to, hey, I also partook in the most heinous of these crimes, really, the rape. But yet they said in closing, Jason Autry told the world what happened that day. Well, if he left even just that detail out, then he didn't tell the world what happened.
Enough to show, yeah, there was some crime committed by these people. You took the position, this is exactly what happened.
this is what happened to, if I look at the evidence, I listen to his testimony, ask what's corroborated, what falls in line, that this is a highly corroborated account of what happened that answers a lot of questions.
Highly corroborated as to what Jason Autry did in his movements.
That's true, because he's not present for where Dylan is afterwards or where Zach is afterwards or things like that.
And none of the evidence y'all had or still have connects Holly Bobo to Jason Autry's story. In other words, y'all didn't know in any time before Jason Autry's proffer where Holly Bobo was after leaving her house.
That's correct.
Dylan says she was alive for several days. In September of 2014, Dylan says in a story you say didn't make sense that she was alive for several days. Right?
At least one version of Dylan's story has her alive I'll take your word as days, I don't remember.
Now, Mr. Scholl said something, page 12, line 23.
Is this the same transcript?
Yes, Your Honor.
This is from Exhibit 106.
I do want to say one thing for the record that we discussed, Your Honor. There was no formal agreement in this case between defense counsel and prosecution until about 1 month ago, within the last month. So no offer was conveyed or given to Mr. Autry until just a few weeks ago when I did set up the Skype with TDOC. I wanted to get that clear for the record. The court, no formal agreement because they would have been, the other co-defendants would have been entitled to that. I think everybody suspected the agreement would be forthcoming, but no formal agreement was reached until you say about 30 days ago. And I have looked throughout this for any distinction or objection you raised to the court's statements of this. Fair to say you raised none. When the court says he suspected, you say, hold on, Your Honor. You didn't object to the court saying that. Didn't interrupt him and say that's not true.
No, that would be in the record.
All right. You use the word gamesmanship.
Oh,
Why this
recall.
distinction of formal agreement? Was there an agreement? Mr. Scholl said formal. My question is, was there an agreement?
Yeah, there's
This
an
is
agreement
beautiful.
that his truthful testimony would be taken into consideration.
At no point is it your testimony that at any time after Mr. Autry testified or before, between the proffer and his testimony and his plea deal, did anyone from TBI who is currently employed by TBI come to you and say, General, I think Mr. Autry lied about what happened that day?
So I thought about that at lunch, when you asked me, and, I said
Lunch?
no, and I still don't remember that. If it could have been a particular point, if you could direct me to a particular point, like, could someone, I don't have any knowledge, could someone have come to me and say, I think that, a point or something? I don't remember.
You're a man of integrity, are you not?
I
Yeah,
try
no.
to just answer honestly and treat people fair.
And if a TBI officer that you trust and respect came to you and said, I don't believe Jason Autry's proffer,
Oh, I would report that.
you'd have a duty to report it, wouldn't you?
Why are you wincing?
I don't know if I had a duty to report it, but I have a duty that if someone said that to me, and then you asked me later, did somebody say that
Fair
to me,
enough.
I should say, yeah.
Whether you had a duty under the strict rules of Brady, you would feel the need to do it, wouldn't you?
Well, it wouldn't have stopped there. I would have been like, what do you mean? And then that would have led to something.
Right.
And if whatever it led to very well could trigger some sort of duty under Brady.
Thank you for your questions and your service.
Cross-examination.
Thank you, Your Honor. Is it fair to say, Mr. Hagerman, that
12
within
jurors.
the Tennessee Bureau of Investigation,
How long do we think it's going to take for her to mention 12 jurors?
there were disagreements about this case?
Oh, yeah, and there was, this case happened before, I came in at a certain
Right.
point, and there had been a lot of drama in TBI with Dicus and other TBI agents about this case.
So you had a career, experienced, well-respected TBI agent who believed with all that he had that Terry Britt rather, kidnapped, raped, and murdered Holly Bobo.
That's right.
To the point that intel that came in to law enforcement in the hours and days after Holly Bobo was last seen was ignored. Completely brushed under the rug, not looked at, not examined.
There's been testimony that the entire department ignored tips that were coming in. So this is again the disingenuous framing of questions.
That's right, and I met with Mr. Dicus in his office before the trial. We expected that, he may testify during the trial. And we had a pleasant, it may have gone on 30 minutes, like we talked for a good amount of time. Two things frustrated me, and one's just me complaining, and that is his opinions of the case were all based on the case as it existed in 2013, and he was forming conclusions based on 2013 and not what happened since then. But the thing that really got me, and I think this is what you're referring to, I'm not sure, but Mr. Dicus had made a statement early on in the investigation of, some sort of IR or something, saying that these defendants, they turn out to be defendants, alibis were verified.
Right.
And that just wasn't true.
They alibied each other.
And you go to, except for Autry, who says he was working on the farm, you go to the farmer guy, and he's like, no, he wasn't working on the farm that day.
Right.
I don't believe the general talked to the farmer.
He read the IRs, he read the investigation.
All right, so what's your
The hearsay as to what the farmer, he wasn't present to that. If the statement is the IR said it, I'll let that find.
It's also not for the truth, it's for the discrepancies
Fair.
in the stories. So, Judge Joe.
Thank you. Jason Autry made up some story
That's right.
about where he was.
That's right.
Zach Adams, Dylan Adams, and Shane Austin, oh, nothing to see here, officers, we were all together.
That's right.
In fact, when you came on the case, your initial, the lens that you put on to look at the case was convince me that these four have done this crime, because we've got all of this intel and this information on Terry Britt, and we have well-respected career TBI agents and FBI agents and a U.S. Marshal that are all convinced that Terry Britt did this. And I gotta know in my heart of hearts as a prosecutor that Shane Austin, Dylan Adams, Zach Adams, and Jason Autry committed this crime beyond a reasonable doubt. Is that the lens that you first reviewed all of this evidence with?
That was my attitude when I was asked to be on the case. I'd heard about the case. Obviously, this, had made news. I didn't know the details of the case or the facts of the case, but I had been exposed previously to the Terry Britt side of this. I'd happened to be interviewing witnesses with a Shelby County deputy who was asked by Dicus to look at some of Terry Britt's phone records and things like this. I think maybe even look at the defendant's phone records.
Which didn't match up. That alibi collapsed.
And so I had been exposed to the Terry Britt side. And when I was asked to be on the case, I'm like, well, look, I know this. I'm not going to prosecute this if I don't believe these people, did it. And so I did come in with a healthy skepticism. I consider it healthy skepticism of the case, and really dug into that hard drive and all the IRs and everything with no assumptions that these defendants were responsible.
So we fast forward to, you're deep in the case, you're on the team, we're gearing up for trial. All three are set for trial, correct? Shane Austin has committed suicide by now, correct?
Yeah, he had already committed suicide when I got on the case.
Before you even came on. All right. Now we've got Jason Autry, Dylan Adams, and Zach Adams set for trial, correct?
They're all, I don't know if set's the right word, but they're all
together.
Impending trial, yeah.
We're all for one, one for all.
Yeah. There was no quote unquote cooperator at that point.
Right.
Yeah.
And unless and until a criminal...
Well, they just said the quiet part out loud. We've laid out the successive eras of this prosecution with Doug Bates on direct saying, well, yeah, you went for Dylan, you realized Dylan was going to be trouble, and then you start looking at Autry. Oh, no, we didn't really do that. That's not what we did. Well, really? Well, what about these timelines where Autry, suddenly there's this plea colloquy that isn't known to be a plea colloquy, but it is a plea colloquy, and we know there's not going to be a trial date set. So what else is this what else is this proceeding going to be? And you time this conveniently for right after Dylan Adams takes his plea deal, and after the mid-2020 summer appeal efforts of Zachary Adams are deaded. They fail. So the appeal should be case closed. All of a sudden, you want to give Autry a plea because you don't need him anymore, and you don't want to deal with taking him to trial. And now we're switching this whole little story here. And shout out to Aaron being a member for 5 months. Thank you, Aaron.
They're all together.
Impending trial, yeah.
We're all for one, one for all.
Yeah. There was no quote unquote cooperator at that point.
Right.
Yeah.
And unless and until a criminal defendant in any of the criminal courts in the state of Tennessee approaches a court or his lawyer and says, I want to plead guilty, the only other road to go down, the only other door to open is a trial, unless we, the state of Tennessee, are going to null pros the charges, correct?
That's right. And it's the state too can elect to try one defendant and then the next or whatever that is.
And there are legal and strategic reasons that we make as prosecutors that we're sometimes forced to make by judges because of Bruton or other issues as to whether or not we try defendants together or separately.
That's
correct? Explain to the court if Creed McGinley, Judge McGinley, had told the state of Tennessee, you got to go to trial on Jason Autry first. What would have been your proof against Jason Autry?
Yeah, so at that time our proof we would have seen if Dylan Adams was willing to testify, assuming that we were going to try the case. Mm-hmm. And so we'd have Dylan Adams we'd have the fact that Jason had lied about his whereabouts that morning, because by then it had been disproven, this verified alibi that about working on the farm.
Right?
We didn't know the significance of the cell phone records, until we hear, Autry's testimony. So
This is the trap I've mentioned earlier in this stream. They are laying out the catch-22 they set up for themselves. They're saying, oh, Terry Dicus said the guys were alibied, but he didn't actually go and verify their alibi. We did. But now we're hearing again, and there was a bit more discussion on this at the beginning of this testimony on direct. They don't look at this cell phone data. So what work did they do to unravel the alibi? Because so far it just seems like Jason Autry may have been going to try to do some meth in the morning and didn't want to say he was busy doing meth in the morning when police talked to him about doing drugs. What were you doing? I'm just going to volunteer. I was doing other illegal activities. No, he probably didn't want to admit that. And that's the inconsistency that they're harping on, that all 4 alibis fall apart. The same person that lied to us is now somehow down the line going to become our star witness at trial. He's the one that unravels. Maybe because he just doesn't want to tell us that he was doing drugs. But still, he's going to be our star, most credible, most compelling witness at trial. It's wild. And it's all an admission that they didn't research the information that was available to them. Just like they told Jennifer Thompson, we have his testimony now saying, yeah, Jennifer Thompson did tell us the files were inaccessible. And our response was, hey, it's the same for us. Which means you never went the extra mile to go make those files accessible and see the alibi evidence. You're just spouting off to this court here that you somehow undid their alibi. And to me, it looks like hiding the hand, prosecutorial misconduct, that perhaps Terry Dicus had seen all of this stuff and was the only one that saw this stuff. And Terry Dicus was truthful when he was saying their alibis checked out. And everybody else said, oh. And here we are.
that's about the extent of our proof. He had made some statements to I believe his wife, Lisa, but she had recanted by the time I was on the case.
She told y'all to pound sand, right?
It was before I was on the case, but she told Miss Nichols and Mr. Lapone.
Don't call
Yeah,
him.
exactly. So our case against Mr. Autry was extremely limited.
And Dylan Adams could have told you, I ain't playing, I'm not going to testify.
He could have.
How likely would you have been to get past a motion for judgment of acquittal
No,
in the
with-
state of Tennessee versus Jason Autry?
No, without Dylan Adams' testimony, we couldn't have tried the case.
Had Jason Autry been seen by law enforcement officers with scratches all over his arms that he lied about?
No, ma'am.
Had Dylan Adams?
I don't believe so.
Had Jason Autry been seen by volunteer, I don't know what you call them, good-hearted people looking for Holly Bobo, trying to find some justice for this community and for that family who posted up in the property?
So is she trying to now, after saying Jason Autry is a liar, is she now rehabilitating him 2 seconds later by saying, did he lie about scratches on his arms? Which, by the way, the only evidence on the record of the lies about the scratches are from a park ranger saying that on April 4th, he personally didn't observe scratches on Zachary Adams. There's evidence on the record that contradicts that. We have Rebecca Earp saying he had scratches all the time. We have the FBI agent, I forget his name, saying, what was his name? Saying that on the 23rd, he takes pictures of all these scratches as if they were supposed to have been incurred on April 13th, the day of the abduction. But they're like these straight lines down his arm, like linear, with like holes, pocks. Almost like they're consistent with drug use and fresh and pink. So the way she's representing this in her questions is there's proof he lied. No, somebody just didn't make an observation that they were present, which you can make an inference. Maybe he didn't observe them because they weren't there. But you could also make the inference that maybe he wasn't looking. Maybe because it was he called in the Henderson sheriffs who came in and handled the impounding of the car for this traffic stop. He wasn't even all that close and wasn't standing to look at somebody's full appendages. And then there's the counter evidence. So just the questioning drives me nuts. And then back to the reason I hit pause, Max summing it up here says, why are you so sure about the first thing and only have belief about the other? Why are we saying this investigation proceeded with integrity because we caught Jason Autry, and only Jason Autry, being inconsistent in his statements to police about where he was that morning? And then you're rehabilitating him by saying, well, he's not the one that lied about another detail, so his credibility is somehow back to 100%. And we're going to put him on the stand, and we're going to tell this court that his testimony at the 2017 trial against Zachary Adams was 100% credible and truthful. And please, Judge Bradbury, please feel the same way about Jason Autry that the trial judge, Judge Creed McGinley, felt. Because that's how we're going to secure and maintain our win. And this is why I lose my voice.
Behind Zach Adams' house, did anybody see Jason Autry vacuuming out a black pickup truck for an hour and a half?
No, ma'am, that was Mr. Zach Adams.
Did anybody see Jason Autry washing a mattress that was leaned up against the house?
That was Mr. Zach Adams.
Did Jason Autry's family have to call 911 the worst night of Karen and Dana Bobo's life?
No, it's Mr. Adams.
And say, my grandson is out of control, he's trying to get my cars and my guns, come help me?
That was with regard to Mr. Adams.
Did Jason Autry run his mouth to anybody and everybody that would listen to him brag about what he did to Holly Bobo?
Notice she doesn't mention the Joe's video 911 call, which, to me, very hard to reconcile how Zachary Adams would pull up midday, mid-afternoon, when all of this is supposed to go on, all of this incriminating stuff would be in the back of his vehicle, pulls up to the Joe's video right within view of the window, and has an argument with Rebecca Earp, his girlfriend at the time. We don't mention that 911 call. That seems to be a serious, serious issue for the timeline. And the common sense of, if he's aware and doing all these other things out of consciousness of guilt, why would he then be driving around with everything out in the open and causing legal trouble where the cops are going to come? If the cops had showed up because he started an argument at Joe's video, you don't think that they would look at his vehicle or say, hey, we're taking you under arrest? We've got to do something about your vehicle that you're leaving here? Like, the theories don't jive.
No, like I said, we had potential statements to Lisa Autry that she had, as you put it, told us to pound sound, but Mr. Adams had made statements to at least 20 people, I'd say.
And y'all put him on at trial?
We put probably 9 or 10 on at trial.
Victor Dinsmore testified at trial, right?
Yes, ma'am.
Everything that Mr. Bates has asked you today about the guns and the water and the discrepancies, do you believe sitting here today that Victor Dinsmore has told you everything he knows about this situation?
No, I don't.
He tested, the jury heard it though, right?
Yes.
And they were instructed to judge his credibility just like everybody else.
Victor Dinsmore was not cross-examined on the same issues that Doug discussed just within this portion of the hearing with Paul on the stand. So, if anything, Amy's making a case for an ineffective assistance of counsel claim.
That's correct?
Yes, ma'am.
Do you believe sitting here today that Jason Autry has filled in everything that he knows about Holly's last moments on Earth?
I bet there's still more he could tell us.
Is that unusual?
It's not.
How long had you been handling cases with Mike Scholl before the Holly Bobo case?
So since I started, so 2001.
I mean, probably hundreds, correct?
If you count small cases, I was talking before about, murders and things like that, but If you count small cases, I mean, you see them every day at 201 and you're
Sure.
handling cases, so
Small, medium, large.
add them together, probably hundreds.
Medium.
Is it important in the world that we function in, the criminal defense world, that your word means something?
Yeah.
Have you been lied to by defense attorneys before?
Sure.
Have you been tricked by defense attorneys before?
I'm sure I have.
Have you had co-defendants, accomplices try to pull one over on you before?
Yes, I have.
Did you at any time?
I'm sorry. Have you been lied to? If on cross, I'd be like, what reports have you made? What reports have you made about unethical behavior by defense attorneys? And really, what's the relevance to this matter?
Get any sense that there was something not right about this Jason Autry Mike Scholl deal?
No, to the contrary, like, Mr. Scholl brought Mr. Autry into that proffer session, and, there are proffer sessions that go a certain way, where the defendant tells you a little bit, and you gotta stop, the attorney goes outside with them, they come back in, they tell you a little bit more, the prosecutor or the case agent gets on to him a little bit, and then you get a little bit more. We got none of that. He sat down and just immediately started at the start and went to the end, and it was the same as we heard at trial.
This is a problem. You didn't vet any of his retelling of the story at all, even though you've been on alert that you should have concerns about Jason Autry in particular's credibility, because he lied to you about his whereabouts of the morning portion of the day. So you just let him proffer, and you don't probe? You don't try to corroborate anything? You don't try to say, if you ask things in a different way and poke at the details, if he can keep consistent? You just let him start to finish, even though you admitted in this hearing that you hear all the time defendants will try to give you a story from start to finish, but they'll leave things out. So you got to probe, you got to investigate further, you got to poke more. You let him just go start to finish, and you let it be. And you said, yep, put him on the stand. It sounds like you didn't want to hear more, because you wanted that story told on the stand, and if you probed further, putting him on the stand would have meant you were suborning perjury. This isn't how that's supposed to work. Shout out to Charlie tuning in now while I'm screaming at my screen. Good to see you.
Mr. Scholl, as I testified before, had told me, we didn't give Jason X and Y phone records and things like this, but we wanted to vet the story for ourselves because.
But you didn't look at the phone records.
It was unlike most proffers because he just sat down and told it.
And this,
because that's not how a proffer is supposed to work. You don't just take what someone says and let it fly because it will help you get a disposition for the trial you have pending, and then let you close out the rest with a plea deal style resolution after you get what you want. This is wild. It doesn't surprise me. It's just wild to see it spelled out loud.
this proffer didn't just happen in one instance. That he tell you his version of what he knew, Jason Autry, with Mike Scholl sitting there. And who all was in the room?
It's me and Jennifer Nichols. There was at least 1 or 2 Shelby County SWAT officers for security.
Sure.
Mr. Scholl.
So where were the notes? Because when we were reading the petition yesterday in our deep dive number 7, part 7, we started reading the petitions, and one of the points of argument from Zach Adams' team is no law enforcement were present during this proffer. So there's no notes, there's no documentation, there's no record of what actually happened during this proffer. So even though they're saying, we didn't really ask any questions, we don't know that. We don't know how any verbiage or offers of leniency may have went, which means Jennifer Thompson couldn't have that material available to prepare and perhaps cross-examine Jason Autry on during the 2017 trial. And we also have no notes to see, did he actually even tell the same story during the proffer that he told on the stand? The only way we would know that is if it was the prosecution's choice at trial to question him and impeach their own witness. And strategically, why would they do that? Not reliable. Yeah, being a Posy McPositon for real. I can't help it. This is ridiculous. This is ridiculous. Exactly, Aaron. We don't know if his story was consistent during the proffer and on the stand, except if we take it at face value that the prosecution didn't impeach their own witness, who was their star witness in the prosecution against Zach Adams. It wouldn't be strategic for them to to impeach Jason Autry. So,
Believe Mr. Paris. I don't believe TBI was present. I don't believe TBI was present, so I think that may be about it.
All right. I'm going to pass you the document. May I approach him? You recognize it? You recognize this?
This is the proffer letter.
All right. And what is the date on that proffer letter?
January, the copy's not great, so I can't tell if January 17th or January 7th, 2017.
I believe it's January 17th. But if you're not correct, it's not a great.
This is 17th, because the signatures are on the 18th.
All right. Your Honor, may we have this marked as the next number?
Objection, thanks.
None.
Mark is exhibit 107.
All right. Thank you. And here's one for the judge. Thank you.
Thank you.
In fact, this proffer, did you ever done a proffer before January 17, 2017?
Yes, ma'am.
Okay. And this one, was this unique, or was this boilerplate language that you cut and paste from the last one you did?
It was boilerplate up till the end.
And what's different about the end of this one?
So there's language in here at the end. If you look at the 1, 2, 3rd, the third paragraph, third real paragraph that it goes on to the next page. And on the next page, it has like it should all be one sentence, but it's cut up here. Normally, what is said during the proffer can automatically be used for impeachment. Here, Mr. Scholl had negotiated language which attempts to limit what he says in the proffer in case his client is tried. So we're not talking about not disclosing statements he made during the proffer, but in case his client is tried, limiting our ability to cross-examine him with regard to what was said in the proffer.
So what he says in the proffer, if he decides to tell you all, I want a trial, all bets are off, you can't use what he's told you.
That's right.
Right. If one were keeping a tally, Mr. Scholl and Mr. Autry came out way ahead on this.
They were negotiating from a position of strength. They were well aware that Lisa Autry had told us to pound sand.
Right.
They were well aware that Dylan's account wasn't full and didn't account for many things. So they were negotiating from a place of strength, and I think they were aware they had answers to all those questions that I had just talked about, and knew sort of the power of what he could bring.
How many jury trials do you think Mr. Scholl had handled by the time he was put on the Bobo case?
I'm going to say at least 100.
Easily. Right. Savvy enough to probably assess on his own what you and Ms. Nichols already knew, and that was, we ain't got much of a case on Jason Autry.
Yeah, there's no doubt about that.
Strongest case was against whom?
Zach Adams.
As a 404B.
How many interactions did you have with Jennifer Thompson, Jim Simmons, and Jerry Gonzalez, the defendant's trial team.
Oh, my goodness. With Miss Thompson and Mr. Simmons, in person?
In person, over the phone, in
man.
emails, text messages.
Oh, my goodness, hundreds and hundreds. Not Mr. Gonzalez, though. He came in at the very end, so his first day in the trial was the first time we'd met him.
Okay.
Oh.
But with Mr. Simmons and Miss Thompson,
Hundreds.
okay? Did Miss Thompson know this file
Yes.
on a scale of 1 to 10, with 1 being really didn't even know what date the murder?
She keeps making this argument, but that's not the way that Doug Bates in the petition is arguing this point of issue. There is no dispute. And we even see Doug Bates draw this out when Jennifer Thompson's on the stand. To be fair, she takes the stand after Paul, I think the day following this proceeding. So she hasn't taken the stand yet in these proceedings. But the theory of Jennifer Thompson is she was doing great up to a point until trial started and she felt beaten and tattered down. They do raise a specific issue with Jennifer Thompson's inability to access the ATM, the BP file, which we've now heard through these proceedings. They changed the file name to take, I think, the word ATM and maybe surveillance out of the file name at some point in time. The discovery records weren't OCR'd, so I think optical character recognition. Shout out to you guys in the chat helping me learn what that is. I just knew it was, if something's on paper and you OCR it on PC, it's now readable. You can search for keywords. So it's very hard to find things buried in 4 terabytes of data if the file names, the keywords are removed from the file name, and if the written documents aren't searchable by keywords. And Doug has made a very specific argument that before the trial started, his ineffective assistance of counsel argument relates specifically to certain details, like Jennifer Thompson saying she couldn't access this file, and then trial happened even though she never got access to it. And he's also raised a prosecutorial misconduct claim on that same issue. So for the counter argument to be, well, she wasn't ineffective because she knew this case file before trial happened, isn't addressing the actual arguments being raised in the petition.
Murder was committed, and 10 being knew everything inside and out. Where was she?
To the degree, I studied this, and I know it's been years now, so there's plenty of things I don't remember. I think that's probably been obvious. But I studied this thing for a year or two or more, and it was basically all I worked on for a year or two or more. I made dozens and dozens of trips to Parsons and Lexington and various prisons and everything for this case, and studied that hard drive, which was 4-point-something terabytes, and all the IRs and the binders. And TBI would joke with me, Joe Williams, and then would joke with me, Joe Walker, and then would joke with me that they thought I had the file in my head. We got to the trial, and Miss Thompson had asked a question or attempted to bring up something about a witness, and everybody else looked at each other like, who's she even talking about? Well, I knew who she was talking about, but just barely, because she had studied this thing and she had lived this thing for longer than I did, because she'd been on the case longer than me. I don't think you would have found an attorney that would have put the time and the effort into studying this thing like she did.
We've all tried cases against defense attorneys who can barely get up enough energy to walk in from the back of the courtroom to their seat for jury selection. And then you try cases with those attorneys who exude energy, who are just on top of everything, who set a tempo. Which one of those camps did Miss Thompson fall in?
No, she lived this case, and she was a vigorous, zealous advocate for Zach Adams and his innocence. And yeah, I was very impressed with her knowledge of the case and the details. She would find stuff in attachments that hadn't scanned properly, or I think she even found there had been maybe on a receipt or something that was in somebody's car, and I don't even think it was anybody important's car, it said there was like an undeveloped roll of film or something, and she wanted that film developed, you know.
And did y'all get it developed for her?
Yeah, they did, TBI did. So I remember having to go into the evidence reviews in Nashville that I talked about. They took all these, at the time, they didn't know where this happened, and with the assumption that it may have happened at Zach's house, they took all the wood flooring from a room in the house. So these are boards that they had stacked up at, TBI. Well, Ms. Thompson wanted them to put together. She wanted to see what it looked like, when it was actually in Zach's house. So we got down on the floor and we, put these boards together so it looked like the house.
Right. Did any other defense attorneys ask for that?
No, that was Ms. Thompson. And I didn't mind it. Some people thought that she was wasting time, but no, she lived this thing. There was another time during the evidence review, TBI had found a note that turned out had nothing to do with this case, but they had found obviously a note that had been torn up, and so it was like little pieces of paper, like you can imagine on the side of a road or whatever it was, and there was an IR about it, and I don't think the IR said like TBI took the time to put it back together, for the time being to see if it had anything to do with anything, and it didn't, and the IR talked about that, but the IR may not have said exactly what the note said, just that it wasn't relevant or something, like this. And so we're in the evidence review, and she insists on stopping and putting the whole thing, together herself so she can read it for herself. Like she didn't miss the big picture. I'm not saying that, but she was into the weeds this, like crazy on this.
Sure. And the big picture, in the history, well, let me ask you this. Have you ever had a case in which the investigating agency zeroed in on one suspect and you indicted a totally different suspect? In other words, have you ever had a situation like this Terry Dicus dichotomy?
I may have had a situation.
It happened in the YSL trial in relation to the Donovan Thomas murder. So, I mean, if we're going to talk about examples that still leave more questions unanswered than actually answered, that's a example that comes to mind.
Situation where there was an extensive investigation on one person.
Sure.
And then it turns out to be a different person.
Sure.
I hadn't had a situation where you had the former case agent still sort of go into the mat with regard to the first. So that was unique.
He testified, Terry Dicus testified for the defense, correct?
Correct.
Former FBI agent testified for the defense, correct?
He was called by the defense, yes.
Former U.S. Marshal testified for the defense,
Yes.
correct?
Yes.
And this was not testimony along the lines of chain of custody or inconsequential form over substance conversations. This was, you TBI have the wrong guy.
I think with regard to at least two of those, with regard to Walker, the marshal,
Yep.
and Dicus, the TBI agent, that's how I would characterize it.
Right. You got it wrong, and Terry Britt is your guy. You all put Terry Britt on, correct?
Yeah. Yes, ma'am. Sorry.
Jury met him, jury listened to him, jury sized him up. Did Jennifer Thompson cross-examine witnesses?
Yes, she did.
A lot of them, right?
Yes.
In addition to the 3 that I just mentioned that she subpoenaed, did she subpoena other witnesses for the defense?
Yes, ma'am.
Did she hire experts?
Yes, ma'am.
She give an opening statement?
She did.
She give a closing argument?
She did.
She make objections throughout the course of the trial?
Yes, ma'am.
Was the defendant engaged in the trial process, or was he sitting back there asleep?
Oh, he wasn't asleep. Mr. Adams was asleep.
He talking with his lawyers?
He appeared to be talking. He appeared attentive, and he did not cause any problems or anything in the courtroom. He was
Shout out to
engaged.
J Money with
Jennifer
5
Thompson put
gifted.
him in suits every day, right?
He was dressed. I believe he was dressed up every day. Yes.
Okay. The jury heard all of that defense. They heard everything that Mr. Bates has asked you about today, and they heard even more, correct?
That's correct.
They heard from the 9 people that you all called out of the long list of how many ever that the defendant ran his mouth to, correct?
Yeah, this is a hard case to defend. Mr. Autry's testimony was persuasive, and that's direct testimony. I mean, he saw what he saw and heard what he saw. So you have this huge piece of direct evidence coming at you. We were able to present numerous items of things that corroborated whether or not it may not have been forensic evidence placing Holly in a particular spot at a particular time, but there was evidence that corroborated Mr. Autry's account. So you have this huge chunk of direct corroborated evidence. And then you've got this list of 8, 9, 10, 11, I don't know the exact number, people who had witnessed statements from Mr. Adams' own mouth that were highly incriminating, some inflammatory, and some quite insightful. There was one in which he had stated, they don't have a body, they don't have a gun, they don't have a case. Well, that's the truth. They didn't have a body, so how would you have known she got shot? And so that was, particularly sort of compelling. So you had this list of 9 people who were like, you said this, and you said this, and you said this, and some of them were very damning. On the other,
We find out that Jason Autry gets that information because his mom calls and relays to him what they're saying. So he didn't even need the discovery folder to hear that detail, that there was a bullet wound to the skull when they found Holly's remains. So
other side, you got the huge, direct, sort of corroborated story, and then you had little shots of circumstantial evidence, like the scratches, like lying about where you were that morning, like having to call 911 later that day, like the searchers seeing you as soon as law enforcement interacts with you, start vacuuming out a car for an hour and a mattress that you lean up, a side of a house. And so some cases have direct evidence, some have circumstantial evidence, and some have all these admissions, and this one had all 3 of those things. And so that made it a hard case to defend, I think. But she tried hard, I'll tell you that.
And it had the added element of Terry Britt. The greatest some other dude did it that's ever existed. And he's a sexual predator who lives around the corner.
Yeah, so the defense has good fodder, for things. Autry, early on, or not even early on, but had given statements that he didn't do it. And so, obviously impeach Autry with regard to that. The location where it occurred, not even able to do crime scene there, so you don't have anybody's DNA or anything like that at the location it occurred. You don't have an eyewitness to the crime other than the people involved. You have the alternate suspect in Terry Britt. So I mean, yeah, you had stuff to work with. We had a battle at trial.
I'm gonna pass you 2 documents. Ask if you recognize those.
Okay, the first, a notice of impeachment and intent to seek enhanced punishment at trial with regard to Mr. Adams. So it's a court filing that's pretty, this is a standard court filing you file before a trial that notices the prior convictions of the defendant that may be used to impeach him should he testify, and then they can be used to seek enhanced punishment depending on what he's convicted of after the trial.
And you all prepared that, you and Ms. Nichols and Mr. Christensen and Mr. Ragland,
Yes, ma'am.
and filed it with the court, correct?
Yes, ma'am.
Gave a copy to Ms. Thompson and Mr. Simmons and Mr. Gonzalez, correct?
Probably all those people except Mr. Gonzalez.
Well, good point. Okay,
Yeah.
but Ms. Thompson got it.
Yes,
For
yes.
sure, and Mr. Simmons got it, okay?
Yes.
And then the 404B, what is that?
This is standard motion in which you notice prior incidents or bad acts that you may seek to introduce at trial, either should they become relevant or because they're inherently relevant. I know that some of these things we had jury out hearings with regard to during the trial or even before the trial.
How many are on here? How many 404B prior bad acts are there in this document?
It's like 12 of them.
And again, this was filed with the court and served on defense counsel.
Yes, ma'am.
All right, now I ask that these be marked as the next numbered exhibits.
Collected as one exhibit or two?
2, please, just for,
I put the one on top that was
Objection,
first.
Mr. Page?
None.
I will mark them as exhibits 108 and 109. I'll make the enhancement notice 108 and the 404B motion 109. Get a copy from me. Mr.
oh, I'm
Clerk?
sorry, yes, sir.
Thank you.
There you go. Thank you. How long did the trial last?
Felt like months. It is hard to answer because we were up here so much for jury selection, and then we had jury selection. I'm going to guess that the actual trial was just short of 2 weeks, maybe.
All right. The end of each night, would you advise defense counsel, here's who you guys might want to focus on tomorrow? Here's, I can't tell you exactly
I
what order we're
did.
going to call
So,
these.
yeah, so before trial, we had to file a witness list of, possible witnesses. And we did do that, but it was quite a few. I can't remember the exact number, but it was quite a few. During the trial, though, I told them at the start, I told either Mr. Simmons or Ms. Thompson or both, I can't remember which one, it was probably Mr. Simmons, that look, our order of proof is going to be flexible. What they really wanted to know was when Jason Autry was going to testify. And I told them, look, he could be very first, he could be very last, he could be in the middle. This is going to be a game time decision.
Why?
Well, that's just how it has to be. Like, you want to establish some facts of the case before you call your testifying witness, so he's just not coming out of left field, for the jury. The jury will have heard that X, Y, and Z happened, and when he gets up there and says X, Y, and Z happened, you've got that established. But you don't want to wait too long that you're 40 witnesses in and nobody has looked at the defendant and said that's the person responsible yet. You risk losing the jury. So order of proof and when you call a witness like that is something that really is a game time. How you think the jury is. Are you losing their interest or are you scoring points and things like that. So something's going to be fluid, and I told them that. But what I did tell them is I would tell them the end of the day, basically who they were going to hear from the next day, with the exception of Jason Autry, who I explained was just an absolute game time decision. So
Sure.
At the end of the day, I tell them, all right.
Game time, gamesmanship. So the key witness who had a whole, I think it was a whole day on the stand he got. Longest testimony, that's coincidentally the one they don't disclose as being called the next day. And that's the same witness that the judge made Jennifer Thompson continue her cross-examination until 7 p.m. that night when the courtroom was above 80-something degrees and everybody's fanning themselves.
Mr. Simmons, probably medical examiner, person that found the remains, and give them 4 or 5 other ones that were going to be testifying that next day.
And oftentimes in trials, things happen. People's travel plans change, or people get sick, and you got to move people around. There's a whole host.
Oh, constantly. During this trial, we had, I believe it was the individual who had witnessed Mr. Adams say no body, no gun. Was supposed to testify one morning, but he was in custody. He was supposed to testify one morning, but instead of bringing him to the courthouse to testify, they had taken him to some work site to work, like an hour away. And so, like, we had to, call witnesses out of order and all this stuff. And I remember, like, when they brought him back, they were finally able to get him here over lunch. And he was in the jail, right behind the courthouse or something. I had to go visit him in the jail, and they accidentally locked me in the cell with them for about 30 minutes or something while everybody else was having lunch. So it was that's how it is with trial. I mean, just witnesses, you can't count on a set order.
Sure. No body, no gun. Was her body found where she was shot in the back of the head by the defendant?
Not according to Mr. Autry.
Right. Was her body found where her phone was
No.
found?
No.
Did you ever talk with defense counsel, Ms. Thompson, Mr. Simmons, both together, about a plea deal?
Yes, ma'am.
Who initiated that conversation? And tell the court about that.
So I believe that the first time we talked about a plea deal is when me and, I can't remember if it was Eric Christensen or Steve Ragland, but it was one of the two, needed to deliver. It was one of those examples of Ms. Thompson wanting something more that wasn't in the discovery. And it was a packet of stuff. I can't remember why we couldn't just scan it and send it. Maybe there was pictures and stuff. I can't remember. But there was a packet of stuff that they wanted, and me and either Mr. Christian or Mr. Ragland drove halfway to Mr. Simmons. And so we met in Parker's Crossroads to deliver this packet with him. And we sat in McDonald's with him for 20 or 30 minutes. And that's when a possible, plea deal was sort of talked about for the first time.
Okay. Was this before or after the Jason Autry proffer?
I've got to, I can't give you dates, and so I'm going to say I'm 98% sure it was after Jason Autry's proffer.
Okay. Did you make an offer?
Oh, no, we didn't make an offer. We talked about, is obviously it was going to be a long sentence if it was going to be something, and I think that's at the point. Whatever was said there in McDonald's about the offer going forward, the idea was, could we structure something like, and I'm not going to get the numbers exactly right, but could we structure something like 40 years to be served at 100% within 15 years or 20 years or something consecutive, but that did have parole eligibility on the back end. And so the Parker Crossroads conversation then became a conversation over the phone with Mr. Simmons and Ms. Thompson and me, and I would have been with other members of the prosecution team.
Okay.
And we at least got to a number-ish, if you would, a number that we were willing to take to the family, and that they were willing to at least talk to Mr. Adams about.
They being Ms. Thompson and Mr. Simmons?
Yes. Yeah, Mr. Gonzalez isn't in the picture. He's not in the picture yet. So we've traveled to, I can't remember if Miss Nichols was with me or not, but I remember we went to the Bobo's house and we spoke to the Bobos about it. And so we had gotten to the point where there was a number that we could live with, which I think was maybe 40 years at 100% with 15 consecutive, something like 55. But then we were told that was a no-go from Simmons and Thompson's side.
All right. So that conversation.
Yeah, so I'm sorry.
No, good.
I should complete, I'll forget if I don't. Then there were plea negotiations during the trial. So after Mr. Autry's testimony, Mr. Simmons approached us asking us if, a life sentence were still on the table.
Okay.
And we told them it would be worthwhile for your client to talk to your client about that. And so I know that, I don't know if Mr. Simmons was part of those conversations, but I know that some members of his defense team talked to him during the trial about that. But again, we got the answer that was a no-go.
All right. Based upon your review of this voluminous file, is it safe to say that the defendant, Dylan Adams, Shane Austin, and Jason Autry were daily abusers of illegal substances? If not daily, several times a week?
Yeah, they all at one point in their lives or another, or multiple points, had addictions to drugs, methamphetamine, but it was I can't remember the other drug. It was like a downer that you could take. It was almost like a speedball or something, some sort of depressant that you would take with the methamphetamine.
They were not individuals who got up every day at the same time and went to a job where they had to be at the same time and did a routine each day and then came home at the same time at night.
No.
Night bled into day and day bled into night.
Yeah, from talking to the witnesses and reading their histories, that's what you get.
After the verdict came back, there were conversations about the second phase.
Absolutely.
Tell the court how that happened.
Well, before the trial, we had, in this weekend, internal discussions, Ms. Nichols and me and the other prosecution members had talked, privately about if we go to the trial and the jury does convict him, whether or not we would make an offer after conviction of life without parole in lieu of the death penalty. And at the time we talked about it, we were all thinking that's probably what we would trend toward, because we would want to talk to the family and the Bobos and get their input, too. So after the verdict and he was convicted, Mr. Simmons, at least Mr. Simmons, I can't say not Ms. Thompson too, because I just don't remember. Mr. Simmons directly came to us asking whether or not there'd be an offer of life without parole in lieu of the death penalty. And I told him that, hey, we're working on it. It was time to go home for the day, so we had the nighttime. And so we discussed it at dinner that night. Ms. Nichols was still a little reluctant. I think she may have wanted to push more than the rest of us maybe, but ultimately it was going to come down to when we met with the Bobos in this room back here that morning, and that's when the family and us came to a consensus that we wanted to make this offer of life without parole. I think there was a sort of stipulation to it that she was be allowed to give a victim impact statement there with Zach in the courtroom, and so that happened.
Were you there after that's over, the courtroom was cleared, and were you there when Jennifer Thompson thanked the Bobos for agreeing to take death off the table?
I don't remember witnessing that, but I do remember people talking about that, and I have no doubt that happened. I just don't think I laid eyes on that myself.
I'm going to pass you what we believe has been marked as Exhibit 101. We've got it on the pad here, and I believe Mr. Hagerman might have the book of exhibits. I don't know.
I do.
I don't know if today's exhibits are exact.
It's a flash drive. We're going to substitute a picture later, so if I may show him that. Mr. Bates asked you about
Can I watch this?
the ATM video, the smoking gun in the case, how it proves we got the wrong people. What are you looking at?
Oh, well, so there's a truck. I pressed play when you gave it to me, so, well, I don't know if I can rewind it. But it's a video. There's maybe looks like a gas station across the street.
Can you see anybody in the truck?
No. I couldn't, but let me rewind it so I can
All right.
have a nice still shot. You may have to do it for me. If you could rewind it to the screen when you handed it to me.
I'm gonna get a piece of where on.
Yeah, Exhibit 101, even though the witness is looking at video, Exhibit 101 is a still shot
Yes, sir.
of what you're about to see.
I just don't think we've got it printed yet, and we're gonna do that on a break. Ms. Fletcher reminded us of that.
All right.
Do you see anybody in that truck?
I mean, you can tell there's a person in that truck. And
Can you tell if it's me?
No. You can't tell who it is. And I think you can probably tell that there's a passenger in the front of the truck
Can
too.
you tell if the passenger is me?
No, you can't.
Can you tell what kind of truck it is?
I can't, but I think a person could probably tell a person who, we have people in this police department who study
Sure.
and who have resources available to them. I think you can probably see enough of the truck that you could tell what kind of truck it is. I can't tell.
But you looking at it, you can't tell.
I can't tell that.
That's all I have, Your Honor.
Pass that back, and I should be using this place.
Well, could the witness keep that and,
We didn't hear 12 jurors.
So we didn't have a printed 101.
On my original handwritten notes, I put that it was on the flash drive with exhibit 102.
I thought we had a printed, but we'll figure it out at the break.
Okay.
Yes, sir.
General Hagerman, could you look at Exhibit 7 in your binder of printed? And go to the front and back.
So my first exhibit I can look at is 12.
Okay, it's probably,
So
Your Honor, can I approach the witness with my copy of Exhibit 7?
You may. Pass it to Chief.
He's just going to look. And can you compare the hubcaps on the photos of Exhibit 7 vehicle with the hubcaps on the general right back?
I am so glad that Trial and Error Podcast uploaded this full thing. We've seen a ton, but now we're getting hubcap questions. And again, there's other evidence that shows that Shane, Zach, and Dylan were all in the Parsons area at the time where this truck is backing into the ATM. So it's not like just because we can't make out faces or how many people are in this vehicle from this surveillance video, it's not like we don't have other ways to demonstrate, really beyond a reasonable doubt, that, which isn't their burden at a trial, that these guys were in this location doing the thing that Zach, before seeing this video, said they were doing, namely backing in, reversing into the ATM lane to pull up to this ATM.
well, at the very least, they're similar. At the very least, they're similar.
And the other parts of the vehicle look similar as well. Extended cab without a door, two-door extended cab. front and back.
Oh, goodness, okay. At the very least, they're similar.
Okay.
It's a little, it depends how light hits stuff,
Sure.
So it does appear that this one on the iPad has sort of a more prominent silver line across it, but that could be how the light's hitting it.
Right. I may have my exhibits, and if you can provide me the exhibits and a sheet, and I'll have to return to the general. Now, as somebody who studied the IRs extensively, do you remember examining IR 1845 that shows all the surveillance cameras?
Not in particular.
What about Joe Walker's IR where he said, okay, Shane Austin says all these guys are together. We've gotten their bank record, and here are the transactions.
I remember, like I said before, I remember something about an ATM transaction.
Okay. Do you remember then talking with Shane, the satellite installer, or receiving of
The cable guy.
the cable guy was there in the afternoon?
Okay.
And you remember the undisputed evidence that Zach, Dylan, and Shane's cell phones had them in Parsons that morning?
Zach, Dylan, Shane. So, my answer is going to be no. I was familiar to me. So there's other things going on with these cell phone things that make it difficult to remember. We had a statement from at least one person that
It's dicey.
at the very least Zach didn't have his cell phone with him that morning. So that sort of like complicated the cell phone talk. So I can't really say, I can't really answer that.
Okay. Well, when y'all want Zach's whereabouts to be precisely known, he had his cell phone on him at all times, right?
Get
No,
him.
no.
Get him.
Well, y'all said that.
We know that he had his we believe that we don't know if he had his cell phone on him that morning. When I say that morning, I'm talking about pre-abduction, time of the abduction. We know that he has his cell phone on him after the abduction, trip to the river and back.
How do you know he had his cell phone on him?
Well, we have Mr. Autry's testimony.
That he had his cell phone on him?
Well, we see the cell phone, we see his phone travel along with Jason's phone to the river and back. We even see it switch towers at the same time.
Right, but my question is, what makes you believe he had his cell phone on when it fits your narrative, and then have no idea where his cell phone is otherwise?
Because someone had given a statement that he didn't have his phone that morning, or had made a statement to that effect.
That's Dylan's. Dylan made that statement. In the
I don't
4-hour
know.
staccato.
Yeah. I don't remember who it was.
Okay,
Staccato.
now,
He's calling Dylan's interrogation the staccato questioning.
account for Jason Autry's story and Dylan, Shane, and Zach being in Parsons at 11:12 a.m. Can you reconcile that?
If I'm remembering my times right, 11 is pretty late. The abduction would have occurred, the rape would have occurred, the shot in the head would have occurred, the travel back to the area of Shane's house would have occurred. So I think we're talking well after the homicide at this point.
Now, do you remember what time Zach and Jason was on the northeast tower by the interstate?
I don't, but
Okay.
Well, let's let the record reflect that Mr. Bates is pointing at Exhibit 15.
At 10:32 a.m. on
39077. And then 3 minutes later on 39079. Do you remember
What was that second time? The one you just said?
1035?
10:35, okay.
Do you remember, did you ever drive routes just to kind of see for yourself?
I did not. I can't, we talked about this, and it was talked about during the trial, because when the defense cell phone expert testified, he acknowledged that it would be possible to travel that distance. You just have to be driving fast.
Are you sure he testified to that?
He did. He testified. He said something like, you could do it, but you'd have to be going fast. And I said something like, well, you know when you can do that? And he said, when? I'm like, when you're going fast. So he did testify to that.
1032, 3 minutes, tower 3979, 1036, 1037, and back at home base with Shane and his activity at 1049.
Okay.
Now, under Jason Autry's theory, the body is still in the white truck, right?
The last Jason sees of it.
Then, does it make sense then, at that point, after calling Autry in to come help him dispose of the body, they then just go to Parsons to lollygag?
I don't know. I mean, it may make sense. You may want to be seen out in public and away from wherever you put this body.
And leave the body at Shane Austin's house knowing the cable installer's coming that afternoon?
I'm not aware of any testimony that was left at Shane's house, so I don't know that.
Well, if Autry comes back, where else would the white truck have been at the last place he sees it?
There's plenty of places around there, and there's woods, and there's Mr. Dinsmore's house, and
But
there's a lot.
have you reconciled the time of how they can get all this and back to the ATM at 11:12?
Okay,
You haven't,
so-
had you?
No.
Because you didn't know that, but you knew they were in Parsons.
Okay, let me answer. I haven't right now.
Fair.
Okay? Did we reconcile that time at the time of the trial? I do not remember.
You remember when Autry said it was the white truck that was hit at Victor Dinsmore's earlier in the day. You remember that?
I remember Autry saying it was the white truck that they were in when they went to the river and back and where the body's in.
And then it was hid at the Dinsmores.
I don't remember that.
And that Zach tells Victor that afternoon, I talked to Sandy about it. I hid the truck at your house earlier today.
I don't remember that.
Do you remember Brent Booth talking to Victor Dinsmore and Dinsmore saying, it didn't happen?
That sounds right, but again, I don't remember it.
Okay. Well, you would agree that you remember the cell phone shows no activity with Shane, Dylan, and Zach for several hours mid-morning between the hours of around 11 and 1.
11 a.m. to 1. No activity with each other or no activity at all
No activity with each other,
with each other.
suggesting they were together.
I don't specifically remember that, but that would not surprise me.
All right. Now, I've heard y'all say a lot that these guys lied about their alibi. You would agree these guys were asked weeks and months after an event to recall a nondescript day if they were innocent.
I'm gonna have to say I don't remember the time frame in which they were first questioned about their alibis. I thought that the tip with regard to them that led to some, at least some sort of questioning was pretty early on. So I don't remember when they were asked about their alibis.
Okay.
It could have been days, it could have been a week, it could have been 2, it could have been a month, maybe.
But you keep repeating, you and Amy Wyrick keep repeating, well, Terry Dykes said they were alibied, but they weren't really alibied. We looked into that and found out they weren't really alibied, yet you know nothing about how this alibi apparently wasn't actually vetted. You don't instead go and vet to see for yourself. You just end up saying, our star witness, Jason Autry, lied about where he was in the early morning, like before 11 a.m., before the time period where he was supposed to meet his girlfriend for their lunch break that they usually met up for. That's it. We keep dancing around the same issue, but we just keep saying, alibi wasn't really an alibi.
And some of y'all star witnesses were asked repeatedly their version of the truth, right?
What do you mean?
Well, Rebecca Earp, were you with Zach that night, or were you not?
That morning, yeah.
Victor Dinsmore,
Yep.
we agree that they gave continuing statements until the moment they gave the most beneficial statement to the state, and then they were never questioned again about it.
Yes.
No, that's not true.
Oh, listen to that lack of confidence. No, that's not true.
It could have been a week, it could have been 2, it could have been a month, maybe.
And
Get him, Doug.
some of y'all star witnesses were asked repeatedly their version of the truth, right?
What do you mean?
Well, Rebecca Earp, were you with Zach that night, or were you not?
That morning, yeah.
Victor Dinsmore,
Yep.
we agree that they gave continuing statements until the moment they gave the most beneficial statement to the state, and then they were never questioned again about it.
No, that's not true.
Victor
Hey,
Dinsmore
Doug.
wasn't?
You've mentioned Dinsmore's statement, I guess, to Booth, that I simply didn't listen to. That was
Okay.
Miss Nichols one that listened to that.
Well, clarify for me, when you're asked by Ms. Wyrick, or General Wyrick, do you believe that he testified truthfully to everything, and you say no. But y'all called him, right?
Yeah.
Yes?
Yeah, because I wasn't a witness, so I can't say what's ultimately truthful, or not. I look at his account, and there's so many things that are corroborated, and there's so many things that ring of the truth. I also see in his account that, I think you're going to have to refresh my memory on the timing, but there's at least like 10 or 15 minutes where he's sort of unaccounted for, and I think he says he's driving around, maybe looking at wildlife or something,
No,
to
Victor
that
Dinsmore.
extent. No, I'm talking about Jason.
Oh, Jason. Okay, I'm talking about Victor.
I'm sorry.
We'll go to Jason next.
Okay.
Victor.
I don't remember Victor's testimony.
Is it often at the end of a trial you win and you say, well, I don't know if all of our witnesses said everything truthfully, but that happens all the time, so no big deal.
No, but it's often the case with someone involved that they don't give us every single thing.
Well, let's go to Autry, because you said he started from the
Bottom note
beginning
here.
and went to the end, and his story stayed consistent from start to end. Which is it? That, and he didn't leave anything out? Or General Wyrick's question, did he tell you everything?
Yeah, so like I said, every time we met with him, the story is what you heard, and the story is what happened, is what you heard at the trial. So there was never any, like you would expect, oh, this is what happened, no, it's not, no. It was that the whole time. And then when we look to corroborate it, or whether or not it can be corroborated, we see evidence that, that looks like it's true, that looks like it's true, that looks like it's true. I think if you do the timeline on him with regard to what his cell phone is doing, that morning, and, like you said, he's supposed to be meeting the girlfriend at the health department, I think, where she works. When he gets a phone call, what his route would have been. My memory is there's about a 10 or 15 minute gap. And I don't say gap, but it's 10 or 15 minutes. I think he testified about it and said he was just driving around looking at wildlife or something like
Right.
this. You'll wonder, if you're a smart person, you wonder, was he actually there when she was alive, and was he part of a rape?
Did you believe
You know,
him?
you wonder. I believe what he testified to.
You have any reason to doubt it?
No.
Now, because if he lied about that, you couldn't have put him on the stand, could you?
Well, if we know he's lying about something, we would disclose that. We would disclose that. You know?
But if you knew he was lying about whether he raped her, you couldn't, and he was going to say he didn't, you wouldn't have put him on the stand.
If we knew that he
Yeah.
had raped her, and he said he didn't, that would have been a deal breaker.
Now, the proffer session, you said Mr. Scholl had the upper hand. Would you go so far as to say you knew you were not going to win a case if you just tried Jason Autry?
We didn't want to have that trial. I'll say that. Like, what I would say, I knew I wasn't going to win, because we could get to a jury with Dylan Adams' testimony and with the fact he lied about his whereabouts and things like that. But it was not a strong case at all.
But you come to the conclusion Dylan Adams' statement wasn't true.
That he was holding a lot back.
And then when you
What's
saw
the
the cell
difference?
records, you realized it wasn't true.
So the cell records don't become particularly important until after we hear Jason's account. So it's a timing sort of thing.
But you had them.
Yeah, we had the records, yeah.
So you
But we
don't
don't-
verify Dylan's lying to you until Jason Autry's prepared to testify?
No, we don't know the significance. So, like, we don't know that Holly travels to the river and back.
Again, another concession that we did not look at this phone record evidence. We did not actually check if the alibi that Terry Dykes said checked out didn't actually check out. We just tuned out all of the things that would make the alibi line up with physical evidence. Oh my gosh.
Like, we don't know that Holly travels to the river and back. We don't know what Jason and the significance of Jason and Zach traveling to the river and back that morning is. Nobody's pieced that together at all.
All right. Did you feel safe in Mr. Autry's presence?
You wouldn't. I got along with Mr. Autry. We had a good rapport, and we talked. And I would not want to be alone with. I've heard two versions of Jason Autry. They say when he's off the drugs, he's very friendly, affable, smart, and people don't have a problem with him in the world.
So like if he's
But-
housed in a federal penal facility, he's fine.
But
Oh, like during his December 2023 recanting. That was a slick question from Doug. Because the state's trying to say that he was on drugs. It wasn't a reliable recanting. But he was in the same facility and gets Paul Hagerman to say, yeah, he's fine then, because he's off drugs. That was so slick.
on guards, right? But when he's on drugs, they say he's entirely different character.
If you knew you didn't want to go to trial against Jason Autry, why didn't you nolly some of the charges
us.
against him, including the death penalty?
We were in a
needed the
situation where
leverage.
legally, we weren't going to be able to try them all together. So this is not you don't know what's going to happen at a first trial. You don't know what's going to shake. If Dylan gets on the stand in the first trial and gives an entirely coherent, truthful account of what happened, well, then we got a case against, Jason Autry. So we had to take them one at a time because we can't try them all together.
Right, but you had already come to the conclusion Dylan's statements were not creditworthy.
Yeah, but I didn't signal the end of things. Like, we talked to Dylan. Like, I watched his video, and I believed he was holding a lot back. But we still went and met with Dylan, and we talked with him.
It doesn't strike you as inappropriate to use the death penalty to get the proffer testimony out of somebody you want?
This case was noticed for death before I was even on it.
I'm not saying you made a decision.
Yeah, and when I came into the case, it was Zach Adams who was going to be tried first, and so that's where the attention was.
Your review of the IR is multiple rumors about multiple people having involvement in this case, correct?
Sure.
Most of them, if not all of them, were untrue.
Sure.
Thank you.
Again, thank you to Trial and Error Podcast for having this uploaded, because what we were able to watch initially, let me drop this right in the chat, it's also in the description. What we were able to watch initially, it was only like, it was short. It was like less than 30 minutes, I think. And there was so much in here. So much in here. So I'm super appreciative that we got to take this deep dive, not just for context on this case, but for context for the visualization, for seeing how the sausage is made, the decision on using plea deals and leveraging the death penalty until we get someone who's going to say what we need them to say, because we don't have the other evidence that we need. So, happily angry lawyer says, Max Shart's evil twin. Oh boy. Also, make sure you guys are checking out Happily Angry Lawyer. He goes live on the fly. So it's hard to keep up with when he's going to go live, but he has a ton of new content in the last like 2-3 weeks. So if you've missed it, if you feel like you haven't seen something from him in a while, that's your sign to go and check out his recent uploads and recent live streams. Always a good time over there. Guys, I have the rest of day 7 from the 2017 trial queued up. Let me drop a link to it. It should redirect anyone that's watching over on YouTube, and I think Twitch just restarts. I don't think you need to leave on Twitch. If you're watching on X, you will have to go back to my profile and then look in 2 minutes. You'll see a new live feed starting. Or you can come over to YouTube and hang out with us here. But YouTube, you'll be redirected automatically. I'm just going to get some more ice in my drink, and we'll fire up our 2017 trial rewatch, day 7, part 2. Link to... All right, so that link is in the chat, but you should be, fasten your seatbelts. We're going over there. So see you guys all in like 2-3 minutes.